May I please, Your Lordship?
Yes.
My lord, I filed the civil division petition yesterday.
Yes.
Can list it on next Monday, my lord, coming Monday?
May I please, my lord, I beg to mention item number 12, ma'am. Item number 12 in the daily court list. And my lord, item number 46 in the supplementary court list, my lord.
কিন্তু wrongly listed আছে that it is from my client এগুলো বলতে একটা essentially tag করছে চলো মানে tag বলে সেটা 30 লাখ with criminal this is quite
12 heard of it. Okay. Yes. What is your pay?
My lord, my prayer is that, my lord, item number 12 and 46 both may come up together after vacation, my lord.
You inform the other side?
Yes, my lord.
No objection.
No.
Okay. Mr. A.K. Gupta, learned counsel for the respondent with consent from the other side. As for listening the matter after vacation, along with item number
46,
40,
that is
40,
6, my lord.
46.
RSA number 35 public 2020.
RSA number 35 of 2020.
And my lord, item number 13 is wrongly shown as, my lord, tag this tag.
No, thereafter supplementary
Yes.
list was published.
After vacation, my lord. All right.
May it please your lordship, I beg for listing of RFA 71 of 24, lordship.
When?
Lordship, can it be on next week?
For vacation, not possible.
Then lordship may
After vacation, you can take any date from him.
lordship may kindly fix a date immediately.
Take a date from him.
on 25th
On
Yes.
deeply obliged, lordship.
This matter relates to release of the amount which is by insurance. It will be listed on 9th of April.
motion is from 7 to 11
Order, Lordship. For release of the
Can
amount
it be on
with the
tomorrow?
insurance company.
tomorrow we can try.
Tomorrow.
Tomorrow.
May I please, Your Lordship? I beg to mention item number 25 with the other side consent, Lordship. I'm praying for adjournment.
Mr. S. Peko, learned counsel for the appellant with consent from the other side, as for listening the matter. When?
After 4 weeks,
After 4 weeks. There alone.
obliged.
Yes.
I want to pray for mentioning the case MSC appeal number 198 public 2019.
Yes.
It's a long pending case, and the last posting was on 24 April 2019.
When do you want?
Pardon?
When do you want?
I want it to be posted on 21/4/25.
Under
Yeah,
which
after
category?
view.
Under which category?
After
Hearing?
view vacation.
Not sure under category. Under which category? Hearing matter.
Pardon?
Hearing matter.
Is it a hearing matter?
Yes.
Then Tuesdays or Thursdays? On 24th.
24. My lord, I'll not be.
Okay.
I'll be going
Okay.
outside. This
1st May? 1st May.
1st May.
May I please, Your Lordship? Your Lordship, with respect to item number 8, Your Lordship. Your Lordship, I pray for withdrawal of this instant matter, Your Lordship, on the persistence of the, Your Lordship, the clients, Your Lordship, of the petitioner, they don't want to pursue the matter, Your Lordship, the matter.
Mr. D.S. Dekar, learned counsel for the petitioner submits that he has instruction to withdraw this petition. That is accordingly allowed. CRP IO number 118 of 2025 is disposed of on withdrawal.
Much obliged, Your Lordship.
May it please your lordship. Lordship, in connection with item number 4, my lord, we have filed on additional affidavit yesterday, my lord. Can it be listed on next week any day along with the affidavit, my lord? It's a motion matter, my lord. Next
On the
week,
hearing made by Mr. Your name?
UU Khan.
So you can't learn it counsel for the petitioner. Let's just list the matter.
Next week. The registry will be.
Will not fix any date, but in the next week.
If date is fixed, my lord.
Is there an urgency?
Yes, my lord. Motion matter, my lord.
Maybe.
11.
Obliged.
Along with the affidavit, additional affidavit.
Additional.
Additional affidavit filed by the petitioner.
May I please, Your Lordship?
Yes.
I pray for listing a make appeal for hearing your lordship, any date of after being your lordship.
In the month
Take a date from.
May,
obliged.
13th May. So. Motion, item 1.
May I please, your lordship. This matter is listed land graving, your lordship. Earlier it was listed before the honor court, and there is appeal provision as per section 13 of the land graving. And the honor court asked me to obtain instruction that the appellate authority has constituted. No? I have instruction that appellate authority not constituted by the government till date, that CRP is liable.
Pardon?
There is as per section 13 of the land graving as,
Hmm.
which appeal provision is there. But till date, government has not constituted the appellate authority, your lordship. Therefore, CRP I have filed here. Earlier it was listed and one of it asked me to obtain instruction that appellate authority is sitting or not here. Your lordship, impugn order page 95. My petition for section 8 of the language was dismissed. After that, I have filed a petition under order 9 rule 9. Your lordship, page 55, that petition.
Mr. Islam, you tell me how many adjournments you have taken for cross-examination of PW1?
8.
Eight.
Yes.
And whether you have assigned any reason?
Reason, your lordship, I have reason. Your page 70 onwards.
And
your lordship.
whether you have enclosed any medical documents?
Yes, I have annexed document. Petition
Where?
also I have annexed, your lordship.
Where?
Page 70 onwards, your lordship. I have petition, I have annexed, your lordship.
No, but in support of the plea, whether you have submitted any medical document?
No, your lordship. Sometimes he is out of station, sometimes he is.
Out of state.
But 2 days he has appeared in the meantime, but he is due to his illness.
No, you appeared, you filed Hazirat for your advocate,
No, your
but you remain absent in the court.
Present 31/5/24 and 29/10/24.
So you have filed petition on several dates
Lordship, your lordship.
without enclosing the medical document.
Lord.
And you have gone to Bihar
Lordship.
to enjoy the Sot Puja with your family member.
Lordship.
Then came to Nagaon to enjoy Karua Sat. Is it the ground?
Yes, petition is set there, right?
We are dismissing the petition.
Item 2.
Obliged.
May I please, your lordship?
Yes.
Lordship, this is a transfer petition, lordship. The petitioner is the wife, lordship. He resides in Kokrajhar, lordship. Lordship, the plaint for divorce has been instituted in Guwahati by the respondent, her husband, lordship. Lordship, the notice is on annexure 1, that is page 12, lordship.
At what it says that suit is pending.
Lordship,
At what it says that suit is pending. now.
lordship, it is on the stage of service report, lordship. Notice has been issued on 17/02/2025.
Where the respondents reside?
Respondent resides in Chirang, lordship, but he has instituted in Guwahati,
Why?
showing that he is a permanent, he is currently staying in Guwahati. The petitioner, the wife, is an original resident of Kokrajhar, lordship. Their marital home was at Chirang.
Heard Mr. P.K. Das, learned counsel for the petition. This petition under section 24 of the CPC is prepared by the petitioner for transferring FC civil number 989 of 2024, pending before the Court of Learned Principal Judge, Family Court, Kamruk and Guwahati, to the Court of Learned District Judge, Kokrajhar. Mr. Das, learned counsel for the petitioner submits that the petitioner is working as an
assistant professor, lordship, in
assistant professor of
Saint Anne's College, Kokrajhar.
Saint Anne's College at Kokrajhar, and she has been residing there, and she got married with the respondent Eric, and used to reside at his native place at Chirang. But thereafter, The respondent herein has instituted on divorce suit being FC civil number 989 of 2024 before the Court of Learned Principal Judge Family Court, Kamrup M. Guwahati. It is stated that the distance between Guwahati and Kokrajhar is almost
250 kilometers.
250 kilometers, and as the petitioner has been serving in a college at Kokrajhar, it would not be possible on our part to contest the aforementioned proceeding at Guwahati. And further, Mr. Das submits that though the petitioner shown in the aforementioned suit is addressed at Guwahati, in fact, he hails from Sirang district. Which place of Sirang district?
Lordship, Bengtol,
He
Sirang.
hails from Bengtol of Sirang district. And therefore, Mr. Das contented to allow this petition. Having heard the submission of Mr. Das, learned counsel for the petitioner, I have carefully gone through the petition. The documents lesson record. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Is there any interim period?
Lordship, the stay may be granted till next returnable date. Yes, page 10, Lordship.
We are taking note of the facts and circumstances on the record and also the submission of Mr. Das, learned counsel for the petitioner. It is provided that till returnable that further proceeding of FC civil number so and so state.
Item 3,
Deeply obliged.
Please, your lordship. Lordship, may kindly pass over the matter for a time, please. Obliged.
May it please your lordship.
Yes.
My lord, this is the certified copy of the order sheet. My lord had passed an order on the last occasion. My lord. Your lordship will kindly see the first order in that order sheet is of 8/5/2023. The next page, your lordship will see the plaintiff evidence was closed after cross-examination. Now, thereafter, your lordship will see there were orders where DW1 was to submit his examination in chief. There were adjournments sought for submitting the examination in chief of DW1. Now, your lordship will kindly turn to the third page, order dated 9/11/2023. My lord has got 9/11/2023.
Yes.
Here your lordship will see the defendant, that is DW1, has filed evidence on affidavit along with original documents which were exhibited. And thereafter, the matter was fixed for cross of DW1. Now, thereafter, my lord, there have been a few dates and eventually the cross-examination of DW1 took place. That your lordship will find the very last page, that is on 21/9/2024. the last page of the order sheet. 21/9/2024. Both sides represented, DW1 cross-examined and discharged, fixed 24/10/2024 for further DWs. Now, this is the order the order prior to the orders which I have next in my petition. So 21/9/2024, DW1 was cross-examined, and then the next date, that is 24/10/2024, was fixed for further DWs. Now, if your lordship comes to my petition, at page 35 is the order dated 24/10/2024. Annexure 3, page number 35. Now, here, my lord, I have in the order, it is reflected that the defendant had submitted a petition citing grounds for which DW2 could not could not submit his evidence in chief. That was allowed. Thereafter, your lordship will see the next page, 19/11/2024. Then on that day, also DW2 could not file his evidence in chief. Then your lordship will kindly see page number 38, order dated 24/1/2025. On that date, court was not functional. The presiding officer was on earned leave. And thereafter, your lordship will kindly see.
No, that's all right. On that day, the presiding officer was on leave.
My lord,
But what prevent you in filing the examination in chief of DW2?
that is where what, my lord, on the subsequent, that is the next date, which was on 24/2/2025, we filed a petition saying that the examination in chief was ready. Only thing was it could not be sworn by the DW2 because he had to leave for Shillong for his official work. And here, my lord, factually, I had on the last occasion also submitted before your lordship. DW2, my lord, is an independent witness. He has been called as a court witness, your lordship. Even in the order sheet, it is reflected. He is a civil engineer who had assessed the expenditure of the developmental works carried out by the defendants over the land for which they have filed a counterclaim. Now, the very purpose of the counterclaim, the claim made in the counterclaim, my lord, will not be established if the evidence of DW2 is not allowed. Now, in that view of the matter, my lord, my humble prayer is that here, so far the provision order 17 rule 1 of CPC is concerned, that postulates that not more than 3 occasions adjournment should be allowed. Now, when it comes to submission of evidence in chief of DW2 precisely, your lordship will see the impugn order. Now, in the impugn order, your lordship kindly sees that is at page 42. Page 42 of my petition. Both sides represented, defendant side petition number so-and-so, sought adjournment stating that evidence in chief of other DWs could not be filed as DW2 left for Shillong. Perusal of the case record shows that since 24/10/2024, the order which I have annexed here, the defendant side is taking time. However, the ground of delay today has not been sufficiently explained. Hence, the petition is rejected. DWs closed, fixed 21/3/2025 for arguments. Now, if your lordship kindly sees my petition at page 40. Page 40 is the type copy, 41 is the translated copy, in fact, my lord. Here, we have categorically stated that the evidence in chief of DW2 has been prepared, but suddenly the DW2 had to leave for Shillong for important work and for which the evidence in chief on affidavit could not be filed today, and therefore an adjournment may be granted. So it was only a matter of one last chance, my lord, which has not been allowed. And on merit, my lord, what I am.
No. Before this order,
My lord,
how many adjournments you have
two
taken?
adjournments for DW2, my lord. For DW2, your lordship.
Is it provided in the CPC that for each of the
No,
DW you will get three chances?
that is not there, my lord.
Then
That is not there, my lord. But your lordship will see procedurally DW1 was cross-examined on 21/9/2024. Now, during cross-examination of DW1, DW2's evidence in chief was not filed. The order sheet's last order, if your lordship sees, that 21/9/2024 was the date on which DW1 was cross-examined and discharged. And then 24/10/2024 was fixed for further DWs. And in the impugned order, it has been stated that perusal of case record shows that since 24/10/2024, the defendant
Okay.
is taking time.
Okay, Mr. Chakraborty, I will go through the orders you have produced before the court today.
My lord, and even my lord, my another submission would be, even if your lordship imposes cost to allow my petition, that also, my lord, will be,
We'll see
my lord.
what relief can be granted to you.
My lord. Otherwise, my lord.
Item 6.
My lord, here, your lordship on the last occasion had, my lord, kind to put a question, my lord, whether a revision is maintainable against an order passed under Order 39, Rule 3 of the Code of Civil Procedure, and whether there is any authority to that effect. My lord, here I had come before your lordship in a revision petition because of non-grant of an ad interim injunction, my lord, where simply notice was issued to the other side without taking into consideration my prayer made under Order 39, Rule 3. That is at page 139, my lord. That order was has been assailed here. Page 139, my lord. And your lordship's last order, my lord, also reflects.
Mr. Chakraborty, on the other day, I have expressed before you that I have experience in filing this appeal
My lord.
before this court against refusal to grant ad interim injunction.
My lord, my lord, may I just place one ruling of the apex court
Yes.
where it is, my lord, both ways. Now here, your lordship will kindly take up paragraph 21. 2007 SCC 695, my lord. My lord, paragraph 21. May I read paragraph 21, my lord?
Yes.
It is the acknowledged position of law that no party can be forced to suffer for the inaction of the court or its omissions to act according to the procedure established by law. Under the normal circumstances, the aggrieved party can prefer an appeal only against an order passed under its Rule 1, 2, 2A, 4, or 10 of Order 39 of the Code in terms of Order 43, Rule 1 of the Code. He cannot approach the appellate or revisional court during the pendency of the application for grant or vacation of temporary injunction. In such circumstances, the party which does not get justice due to the inaction of the court in following the mandate of law must have a remedy. So we are of the view that in a case where the mandate of Order 39, Rule 3A of the court is flouted, the aggrieved party shall be entitled to the right of appeal, notwithstanding the pendency of the application for grant or vacation of a temporary injunction against the order remaining in force. In such appeal, if preferred, the appellate court shall be obliged to entertain the appeal and further to take note of the omission of the subordinate court in complying with the provisions of Rule 3A. In appropriate cases, the appellate court, apart from granting or vacating or modifying the order of such injunction, may suggest suitable action against the erring judicial officer, including recommendation to take steps for making adverse. My lord, I'll skip this. Now, paragraph 22, my lord. Now, what remains is the question whether the High Court should have entertained the petition under Article 227 of the Constitution when the party had two other alternative remedies. Though no hurdle can be put against the exercise of the constitutional powers of the High Court, it is a well-recognized principle which gained judicial recognition that the High Court should direct the party to avail himself of such remedies, one or the other, before he resorts to a constitutional remedy.
Learned single judge need not have entertained the revision petition at all, and the party affected by the interim ex parte order should have been directed to resort to one of the other remedies. Be that as it may,
Mr.
now it is,
Chakraborty,
my lord,
this decision is of 2000.
my lord.
Thereafter, there are several decisions of Supreme Court where it is stated that when alternative remedy is available, the petition under under Article 227 is not maintainable.
My lord, agreed. Now,
So
here,
I am granting you liberty, you can
my
withdraw
lord,
this
my lord,
petition
my
and
lord, that
file
is,
an appeal.
that was about to be my prayer, my lord. That actually
Okay.
was supposed to be my prayer thereafter.
Mr. Chakraborty, learned counsel for the petitioner submits that he may be permitted to withdraw this petition and to approach this court again by filing appropriate petition. Here is accordingly allowed, this CRP stands disposed of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Deeply obliged.
Timing tree.
We have please your lordship. Also, you will find the MP in order at page 30, my lord. What has happened in this case, my lord? The petitioner plaintiff filed a suit for right title interest and for cancellation of some sale deed, my lord. And at the time of evidence, the learned court below allowed one chance to file PWs for on behalf of plaintiff, subject to payment of cost. But
Now,
inadvertent,
whether you have paid the said amount.
my lord, because before that, my lord, I will pay, in fact, I will pay double the amount, my lord.
You produce the receipt before this court.
No, no, that admitted,
You
I have
apply the order of the court, thereafter we will hear you, not now.
obliged,
Place the
I will pay in you.
Place the matter after vacation.
Deeply obliged.
Item 7.
Well, it's a suit of 1975 filed by the respondent and its predecessors against the present petitioners and their predecessors. This suit was dismissed in 2007. Thereafter, in 2012, the plaintiff filed an appeal. Now the hearing of the appeal was concluded. At that stage, my lord, on 29/2024, learned court below has, after going through the materials on record, which you will find at page 41. That was a date fixed for pronouncement of the judgment. Madam. Today was fixed for judgment. While writing the judgment, I find it necessary to recast an issue on the point of maintainability. It may be noted that it is well within the jurisdiction of the first appellate court to recast issue. It is a matter of record, and as such, no additional evidence is required to be taken. So I find no necessity to remand it to the learned trial court. Accordingly, the following additional issue is framed as issue number 7 and kept with the record. Whether the plaintiff has locus standi to file the present suit. The matter was fixed for hearing on the additional issue on 24/10/2024, and accordingly it was heard. And thereafter again on matter 3/1/2025, while the matter was fixed for judgment at page 42. Married.
Yes. Mr. Soikia, next date was on 4/2/2025. What happened on that date?
Adjournment was sought for. Adjournment was sought for. And the next.
Today is fixed. My adjournment was sought for, my lord, and today is fixed before the court for necessary order. Before the trial court.
But you tell me, the court has exercised its discretion by exercising that power under Order 41 Rule 27(1)(b).
Yes.
So how this order is illegal or arbitrary?
No, firstly, your lordship will kindly see the page 41. The same court has opined that everything is available in the records to decide the issue, so therefore no
Maybe
evidence
thereafter
is
the
required.
learned trial court or learned district judge, after going through the record, found that the examination of the witness is necessary. And thereafter this invoked the jurisdiction under Order 41 Rule 27(1)(b).
Now, my lord, first of all, my lord, there is one question again, my lord, whether this court will have the power of review its own order on this aspect.
That principle is applicable in criminal cases. In criminal cases, court cannot review its order. So is there any bar in exercising that jurisdiction by the Supreme
So
Court?
far as sumoto is concerned, it is, my lord, only, my lord, section, my lord, 152, my lord.
It is.
That is for correction, etc. Otherwise, my lord, this order 47,
No, this order, is it a final order?
my lord.
Is it not a final order?
It is not a final order. It is not a final order. But the court has opened its mind that additional issue has been framed because it is not required that any addition. And the issue, what is the issue? Your lordship will kindly see on the next page 42. What was the consideration, my lord, by the learned trial court, my lord?
Yes, the
My lord, the
additional
trial
issue is
court-
at page number 43,
Lordship,
paragraph number 4.
lordship,
Whether the plaintiff has locus standi to file the present suit.
lordship. That was the issue, my lord. The consideration is, my lord, in paragraph 2 onwards, that, my lord, the original plaint was filed by one, was verified by one Jetli, who is the personal manager, and he has also said he is the attorney of the plaintiff. Now, this first amendment plaint was filed by the same person with the same authority. Now, the second amendment that is filed in 1999, that was by the manager of the tea state, one Probir Datta. Probin Datta. So this consideration was there whether he has the authority or whether he can represent the plaintiff. Now he is filing the suit, he is verifying or he is presenting the suit as in the capacity of a manager of the tea estate, not for the original plaintiff. Decom Tea Estate is not a plaintiff. It is initially it was the Jokai Assam Tea Limited. Thereafter it was merged with the Jokai India Tea Limited. Thereafter it is renamed the Russell Tea Estate, which owns one of the garden that is known as Decom Tea Estate. Now this person, this Probir Datta, he is representing he is the manager of that particular garden, whether he represents the company. That was the issue. So therefore, in the court on the first occasion on 29/2024, court says no additional evidence is required. Whatever is there in the record, this is an issue. I have to decide on that basis. If the authority is there, if he is there, my lord, then in that case that can be decided. Now subsequently, my lord, this observation has been made, and now question is, my lord, what it appears, my lord, the page 43, my lord, paragraph 4, the court is, my lord, inclined by the, my lord, ratio that has been laid down in 1997 Supreme Court 03, my lord. My lord, that case is altogether on a different, my lord, count. That was a suit filed by the branch manager of a bank, and it was the branch manager who has, my lord, verified the plaint and the, my lord, pleading. Now the court taking into, my lord, these provisions of order 21. Order 29 rule 1, my lord. Court says since the person is as per the, my lord, order my lord, this 29 rule 1, the court can, my lord, presume that he has the authority. And even if the court do not have find it difficult to come to that conclusion, and in that case he can take the, my lord, this additional evidence in exercise of power under this order 41. For ratifying the, my lord, whether the authority is there or not, my lord, or rather ratifying the authority. Now here your lordship will find, my lord, the court is absolutely silent. Court is absolutely silent, and the order 41 rule, my lord, 1B 2, my lord, or order 41 rule 1 2, my lord. He has to assign reason. It is not there, my lord. What is to be clarified by the court, my lord? My lord, this is rule 2 of the, my lord, order 41 rule 27, my lord. Whenever additional evidence is allowed to be produced by an appellate court, the court shall record the reason for its admission. Now the reason what it says, it will clarify. What would be clarified, my lord? Paragraph 5, hence at this stage I am of the considered opinion that for clarifying the matter of fact and in the light of the additional issue framed by the appellate court and for proper decision of this appeal and for answer of justice, it would be proper for calling for a competent authority of the plaintiff. Now, my lord, what is to be clarified, my lord? This is not spelled out here, my lord. Is it for, my lord, filling up the lacuna in the, my lord, the proceeding?
No, no,
My lord,
no.
lordship.
This order is not passed on the behest of any party.
Exactly,
This
my lord.
is an opinion formed by the court.
Well, this will enable the other party to, my lord, fill up
No,
the
no,
lacuna.
no,
That's
no.
what, my lord, it has the, my lord,
No, no, no.
lordship, my lord.
There was
I am
no
not,
such
but
petition of the other party.
it is not under order 41 rule, my lord, 1, my lord, A or 1 double A, my lord. It
Yes,
is 1
yes,
B.
Mr. Datta, what is your submission?
My lord, your lordship rightly said, this order was not passed at the behest of the plaintiff respondent here.
Hmm.
Now, your lordship kindly see, my learned friend is saying that to fill up the lacuna, that will come if we file an application under order 41, rule 27 double A. Now, this is not a case under double A. It is for the satisfaction of the learned judge at B, your lordship will find. The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. So therefore, how they are aggrieved by that? Because if you are filing an application article 227, what is that patent illegality in passing this order? He will have to satisfy to your lordship that. Apart from that, my lord, the lordship sees the evidence that Bharatiya Shaksha Adhiniyam at section 168, that is the prerogative of the judge. 168. My lord, your lordship, can you see 168 judge's power to put questions for order production?
You are referring to section?
168, my lord. Under the heading judge's power to put questions or order production, the judge may, in order to discover or obtain proof of relevant facts, ask any question he considers necessary in any form at any time of any witness or of the parties about any fact, and may order the production of any document or thing. And neither the parties nor their representatives shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to any such question, provided that the judgment must be based upon the facts declared by this adhiniyama to be relevant and duly proved. Now, this is the prerogative of the learned judge, my lord. If he thinks that certain things to be clarified, it's up to him, my lord, he can call anyone. So therefore, it's not an application filed by us to, my lord, give any additional evidence in terms of order 41 rule 27 double A. So therefore, I don't find any sort of illegalities in passing this order. And therefore, petition under article 227 is not applicable at all. And the question of filling the lacuna is not arise at all, because it is not at my behest this order was passed. It is for just to make the clarification by the learned judge whether any officer should be called or any document should be produced. So there is no illegality at all.
Yes.
My lord, the point that what, my lord, to clarify the matter of fact in the light of the additional issue, my lord, what is the, my lord, that fact need to be, my lord, clarified by the witness that has not been stated. The code is to see, my lord, while exercising this power under, my lord, rule B, 1B, that it, my lord, is found it, my lord, necessary for pronouncement of the judgment. Any additional evidence that may be brought on record. Now, here, my lord, whether the question is whether without any, my lord, without any additional evidence, whether he can, my lord, pass the, my lord, judgment or not. Now, this particular, my lord, things, my lord, what is, my lord, that particular thing for which he needs the clarification and which has, my lord, deprive him or, my lord, the court, my lord, feeling it necessary. The clarification on this particular point is necessary for pronouncement of the judgment. That has not been spelled out, my lord. And now, on the other hand, it would, my lord, given, my lord, scope for the, my lord, the plaintiff to adduce the, my lord, evidence to ratify the authority, my lord, of filing of the, my lord, the suit by the person who has verified it. That is the whole case, my lord. The apex court also, my lord, on this count, my lord, this has been, my lord, clarified that it is not an additional evidence under one 1A or 1AA. It is the court only with regard to the, my lord, while exercising, my lord, power under, my lord, this B, rule B. It is only for the pronouncement. The court has to, my lord, come to a, my lord, conclusion that this, if this particular things is clarified, in that case, it will be easier or it will facilitate the court to, my lord, pronounce the judgment, my lord. My lord, in this regard, my lord, I am referring to, my lord, one of the apex court judgment of 1965. Then, paragraph 9. 61008. Paragraph 9, my lord, page 7. And the left side, my lord, second paragraph. Page 7. And the left side column, my lord, paragraph second.
Okay, you read the paragraph.
Lordship, my lord. Paragraph 9, my lord, it starts, my lord, from page number 6, my lord. So it's a too long, my lord, paragraph. So, my lord, Lordship may come to, my lord, page 7. And the second paragraph, which starts with, if the High Court, has your Lordship got it? Now the fourth line from in that particular paragraph, no doubt under Rule 27, the High Court has the power to allow a document to be produced and a witness to be examined, but the requirement of the High Court must be limited to those cases where it found it necessary to obtain such evidence for enabling it to pronounce judgment. The provision does not.
From which line you are reading?
But has your Lordship got it? But if the High Court in making this observation,
Yes, yes.
then come down to, my lord, line number 4, my lord.
No
Fifth,
doubt.
my lord.
Yes.
No doubt.
Okay.
No doubt are under Rule 27, the High Court has the power to allow a document to be produced and a witness to be examined. But the requirement of the High Court must be limited to those cases where it found it necessary to obtain such evidence for enabling it to pronounce judgment. This provision does not entitle High Court to let in fresh evidence at the appellate stage where even without such evidence it can pronounce the judgment in a case. It does not entitle the appellate court to let in fresh evidence only for the purpose of pronouncing judgment in a particular way. In other words, it is only for removing a lacuna in the evidence that the appellate court is empowered to admit additional evidence. Now, my lord, there are several other judgments, but again, my lord, 2001.
No, Mr. Soikia,
Lordship.
this observation relates to the appellate court.
Here also appellate court, my lord.
Which one?
Our court is also appellate court,
Not trial court.
not trial court.
This
Suit
is
was
not
suit-
trial court.
Suit was dismissed by the, my lord, trial court.
Okay.
Then they went on appeal.
Okay.
Now, at the time of pronouncement of the judgment, my lord, this orders have been come. The other judgment, my lord, the another one, my lord, at page, my lord, AR 2001, Supreme Court 2802, my lord. Okay. I'm referring to paragraph 19, my lord. This has also relied on that 1965 judgment. Para 19. Married.
Yes.
Incidentally, the provision of Order 41, Rule 27 has been engrafted in the code so as to patch up weak points in the case and to fill up omission in the Court of Appeal. It does not authorize any lacuna or gap in evidence to be filled up. The authority and jurisdiction as conferred onto the appellate court to let in fresh evidence is restricted for the purpose of pronouncement of judgment in a particular way. This court in municipal corporation so-and-so has been candidly enough to record that requirement of a high court must be limited to those cases where it found it necessary to obtain such evidence for enabling it to pronounce judgment. So in similar, this paragraph I have already read in 1965, that has been quoted. So my lord, the court has to spell out its mind, taking in the note of the my lord, the rule 2 as well. That which my lord, clarification, which point needs further additional evidence for pronouncement of the judgment. Now here, my lord, the court has not evaluated the evidence and said that these particular things are there, and but had there been some more evidence on this point, then the point would have been clear. This is nothing, my lord. Rather, at one point of time, as I have already said, my lord, that court has found that this is a point, whatever documents or the evidences are there on record, so that will suffice. So therefore, the court did not, my lord, remitted the matter to the trial court for taking evidence. Rather, it has heard on that point, and now taking up different, my lord, these verification clauses. Even my lord has not spelled out in the order which point he needs the clarification. And the judgment which has been relied is totally, my lord, order 21 rule 1, my lord. Where specific persons have also been named, that if they file, that means they are competent person to file. This is a company, my lord. They are the company. So secretary, my lord, the director, etc., these have been named.
Okay. Mr. Dutta, are you interested to file an objection here?
It's
No,
not required,
not
my lord.
necessary.
My lord, only one thing I can say. My learned friend has referred the 1965 Supreme Court. Your lordship will find it is in the context of if either of the parties file an application for adducing additional evidence. Not that in this sort of cases where the learned judge want to make some clarification.
Not
So my lord, my learned judge is not, my learned friend is not knowing what is in the mind of the learned judge, why he has called for that particular document or my lord witnesses. Now he is making an inference. If any person comes, if he adduces evidence, he will fill up the lacuna. Where from he is getting that? My lord, it is a premature. If he is making an inference to that extent, the application itself is a premature. The learned judge did not say anything, and you are making reference to that. So therefore, this application, even otherwise also, it is a premature. And the learned judge having all the powers in terms of order 41 rule 27 1B, he can call any person, any document if he feels for the proper adjudication of the case it is required. Even in terms of 168 also your lordship has seen, he has all the power. So therefore this petition is quite unnecessary and is liable to be dismissed in legal.
Only for clarification, my lord, the 1965 specifically, my lord, is on, my lord, order 41 rule 27 1B. As my lord said, it is not on that line, my lord, it is not correct, my lord. It is specifically on B, my lord, sub-rule B. Court exercising the power of, my lord, sumo to, my lord, for the pronouncement of the judgment, number 1. Second aspect of the matter, that I am on speculation, I am filing this, my lord, petition. I do not know what is in the mind. The rule, therefore, my lord, 27(2), 1(2), my lord, specifically says, while admitting, my lord, additional evidence, court must record the reasons. It doesn't have the reasons, my lord. On that, my lord, had the reasons been, my lord, placed, in that case, my lord, this court would have, my lord, definitely said that yes, this is not for the purpose of bringing any additional evidence, for the purpose of pronouncing the judgment in a particular way. Rather, it is for effectively pronounce the judgment. But this has not been there. This is in sub-rule 2, my lord. Okay.
Lord, either of the way, I am not going to agree. If it is, this order is satisfied also, my lord, it will remain the same thing. Now, under what factual background 1965 Supreme Court, their lordship passed that order, your lordship can see that. Because it may not be in regard to the factual background of this case, and that 65 Supreme Court, it may not be in the same factual background. So therefore, the judge has the power to call any sort of document for precise adjudication of the case. That power is there, and my lord, that cannot be questioned in a petition under Article 227. And possibly, my lord, I am sure my learned friend could not satisfy your lordship also to that extent. Therefore, the order is totally illegal, and I mean, the order is required to be upheld by your lordship.
Hardness of pieces, okay, learned senior counsel assisted by Mr. Gupta, learned for the petitioner and Mr. S. Dutta, learned senior counsel, assisted by Mr. S. Dutta, learned counsel for the respondent. Argument concluded, order reserved.
Item
What, you have filed one caveat, Mr. Dutta? Caveat or would be heard, caveat distance research, okay.
Item 44.
May I please, your lordship? Lordship. When the impugn order is at page 27, lordship, annex 5. Lordship, this is the order passed by the Lanet Single Judge, Lanet Civil Judge Senior Division, Shipsagar Division, lordship.
So what is the decretal amount?
Lordship,
What is the decretal amount?
decretal amount is 6 lakhs.
6
something.
lakhs.
Yes. It is not the fact that the petitioner is sitting idle over this subject matter, lordship. He has continually written the letter. The communication which he has written is contained on page 30, lordship.
You deposit 50% of the amount before the trial court, executing court,
Lordship,
then we will see only.
lordship, it is not the petitioner cannot deposit of his own because it is a department, lordship. He has written to the chief
Alright.
engineer, lordship.
You are a department, all right. You compel the department to pay 50% of the amount before the executing court, or you have to go to the jail.
Lordship, sometime may kindly be granted.
No,
at
no,
least
no.
at least 15 days,
You
lordship.
first deposit the amount only, then come to this court.
Lordship, at least 15
No.
days, lordship.
Pardon?
15 days time
No,
maybe
no.
may kindly be granted.
No.
Otherwise, on the next date, he may be,
No.
lordship, next date, he may be put behind the bar, lordship. He being
Sufficient
the,
opportunities afforded to you, you have failed to avail the same, and jail is the proper place for you. Go there.
lordship, then before the next date, he has to file 50%,
Definitely.
lordship.
You deposit 50% of the decretal amount before the executing court
Lordship,
and produce the receipt before this court. Only then we will consider your care.
lordship, then next date is the 7th, lordship.
7.
Means 8th of this month, lordship.
Yes.
That is on Tuesday, lordship.
Yes.
So only 2 days is left, means tomorrow being a Saturday, lordship, and next day is a Sunday, lordship.
Tomorrow is working day.
Yes, lordship. Tomorrow is a
Yes.
working day, lordship.
Yes. On Monday you may come.
Then matter may kindly be listed on Monday, lordship.
Okay.
Lordship.
Okay.
45.
Wait, please, Lordship. Lordship, may kindly pass over the matter for the time being, Lordship.
Who will appear?
KK Mahanto, Lordship.
Items for admission, item 9 and 10. Third method.
My lord, in this case, my lord, I seek for one accommodation. The proposal is not well. He says a 9. If 9 it is fixed, he can accommodate.
Pardon?
9, if 9th of this month is fixed, then the
Sir Bhagavate? I have no problem. No problem.
9th, my lord.
As agreed by learned advocates of both the parties. This is the number. Mr. Barua,
My lord.
yesterday RESI has issued one notification.
Oh,
Only the motion matters will be taken till the 11th of April.
my lord.
So this is admission matter.
I understand. So,
So after vacation,
sir, vacation, my lord. It should be pardoned. Pardoned should be continued.
okay. As agreed by learned advocates of both sides, RESI shall list the matter
Just after you.
immediately after reopening of the vacation. As part of.
Items 11.
My lord, it's not time being, my lord. He's coming on the way, my senior. Obliged.
Item 14.
Your Lordship. In the intervening period since this matter was filed and first heard and notice was issued, in the trial court, the plaintiff evidence is concluded and very many orders have been passed and certain interim applications have also been disposed of ex parte. We would like to bring these certain additional facts on record. They're crucial to the determination of this petition. Your Lordship may give us some additional time to bring these facts on record.
No, not necessarily. It is only order 12-6, rule 6 petition. They have filed. There's a specific my lord, petition was there. It was rejected by the learned court below. So it is not necessary other facts.
Especially the admissions that they've made on record, those are crucial. Your Lordship may give us some additional time.
Heard, Miss?
M. Das.
Learned counsel for the petitioner and Mr.
K. Roman.
K. Roman, learned counsel for the respondent. Ms. Das, thanks for listening the matter after the vacation so as to enable her to bring on record some additional facts.
Yes, sir.
Additional facts. By filing in additional application, there is allowed places to list the matter immediately after reopening of vacation.
Item 15.
May it please your Lordship. But here, my lord, the petitioner was the plaintiff before the trial court, my lord. Impugned order is at page 60, my lord. The cross of plaintiff,
Who is for the other side?
my lord, other side name has been reflected, it's not shown, my lord. It's shown in the cause list, my lord, they have not here, my lord.
MR Sodium. Present. Let him compare after some time.
Item 16.
Lordship, in the last, in the order dated 26/3/2025, as I've shown that I have not filed I sought time for filing objection, but it was recorded that the objection is filed immediately. Because as I have prepared, he took time, the short date, because of the case is fixed tomorrow probably.
On 7th, your Lordship.
So let's say I'm ready to, because on limitation point, he's come up before the honorable court, because trial court is allowed, then he filed misappeal, then that was also rejected, so he has come up with it. Now objection can Lordship can hard because. Yes, Lordship.
May I please, your Lordship. The impugned order, your Lordship, is page 50, your Lordship. It starts from page 50. What happened, your Lordship? In this case, the petitioner and is the plaintiff. He filed an application for amendment of his plaint, your Lordship, and the application for amendment was allowed. And accordingly, your Lordship, the amended plaint was submitted, your Lordship. Thereafter, Lordship, that particular order, to challenge that particular order, they filed a review application, and there was some delay. And that delay application, your Lordship, page 33, that was allowed, and the petitioner challenged the order, filed appeal, and the appeal was dismissed, and hence this revision petition. Lordship, kindly see the observation of the learned court below, page 64, operating portion, your Lordship. Paragraph 12.
It starts from paragraph 11, in your lordship.
Hmm.
It is reflected that the learned trial court perused the medical document submitted by the present respondent. It is crystal clear from averments made in the written objection that both the children of one of the present respondents were minor, as they were the students of class 6, 7 and class 5, as none of them in the eye of law is measured to maintain himself or herself. The impugned order reveals that the petition ought to have been filed within 9/12/2023, but delay in filing the petition was on account of illness of one of the petitioner's wife, and the delay in receiving the certified copies on 18/12/2023. The learned trial court also confirmed that 9/12/2023 and 10/12/2023 were court holidays. This is, lordship, important, your lordships. Now, it appears from the impugned order that the learned trial court has been satisfied on the plea of the present respondents on medical grounds and rightly observed that within 9/12/2023 the petition could not be filed. Lordship, kindly note this portion. Within 9/12/2023 the petition could not be filed as 9/12/2023 and 10/12/2023 were court holidays, and on 12/12/23 application for certified copies was filed, which was ready on 18/12/2023. It is reflected from the impugned order that the learned trial court aptly exercised its jurisdiction in condoning the delay as prayed for by the present respondents before the learned trial court, after discussing all the averments and objections made by the parties, and for the interest of substantial justice. Sufficient cause in section 5 of the Limitation Act is aptly narrated by the present respondents in their petition, and the learned trial court judiciously considered its exercise its discretion in the following petition. From the entire discussion, I come to the conclusion that the impugned order has not been passed on mere assumption. The impugned order passed by the learned trial court is based on facts and law, and it exercises it properly. Now, your lordship, kindly see the application for condoning the delay, which is at page 33. Dear ground, your lordship. Paragraph 2, your lordship, that on 10/11/2023, Honorable Court was pleased to pass the order in Miss J case number 103 of 2023.
Paragraph number?
Paragraph number 12, page 33. Paragraph number 2, page 33. That on 10/11/2023, Honorable Court was pleased to pass the order in Miss J case number such and such. The defendant's OPs are the brothers, and the entire case matter is being looked after and inquired by the defendant OP Sri Usit Bora. That both the defendant's OP did not turn up to inquire about the order dated 10/11/2023, which is inter-party order, and which is inter-party order, your lordship. The respondents was heard while passing the order, and they did not file any objection in the amendment application, which was allowed by order dated 10/11/2023. And as such, in the third week of November 2023, a message was sent about the order of allowing the amendment, but the OP Sri Usit Bora came to chamber of the advocate on 11/12/2023. Order was passed, your lordship, on 10/11/2023, and the respondent came to the office of the advocate after completion of limitation period, your lordship, 11/12/2023, and informed that his wife is undergoing treatment as she became unconscious suddenly. He is to remain busy in looking after the minors as he has got two minors. One is studying in class 5 and another aged at about 6 years, and hence he could not contact the advocate on account of illness of his wife. The medical documents of illness of his wife is being filed herewith. The defendant OP has been contesting the suit sincerely since the year 2013. Next, your lordship,
Mr.
now
Mr.
their
Som-
ground.
Mr. Som, there was delay of only of 8 days.
Lordship, 8 days delay, now your lordship, their ground, your lordship only. And my amendment application was allowed. Against that order, your lordship, they preferred preview. And my amendment to the amendment of plaint, which was allowed, against that order, the respondent preferred review. And in that case also, in the review petition, there was delay. And the ground, your lordship, the ground which is not sufficient, your lordship. And in this amendment application, there is no any affidavit and not supported by any verification, which is mandatory under order 6 rule 15, your lordship. Not supported. Kindly see, your lordship, that application, your lordship. There is no supporting affidavit and verification. Page 33 and 34. And your lordship, the next ground they have taken that 2 days were holidays. Order dated 10/11/2013, but 9 December 2023 is the second Saturday and 10 December is the Sunday. And hence the petition is to be filed 11th December. But the review petition is filed on 19th 12. And while considering this application, learned trial court, your lordship, kindly see learned trial court order. Operating portion, page 55, your lordship. Lordship got it. Peruse the case record. The petitioners have filed the instant petition to condone the delay in filing the review petition. As the petitioner sought to review the order dated 10/11/2023, the petition ought to have been filed within 9/12/2023. But the petition was filed on 19/12/2023. The delay for filing the petition was on account of illness of one of the petitioner's wife and the delay in receiving the certified copies of order dated 10/11/2023 on 18/11/2023, which is jurisdictional error, your lordship. That application was filed after expiry of limitation period, your lordship. Lordship, if your lordship, section 12, your lordship, of the Limitation Act, your lordship. It is specifically mentioned, your lordship, exclusion of time in legal proceedings, your lordship. 12 subsection 2, your lordship. 1 and 2. In computing the period of limitation for any suit, appeal or application, the day from which such period is to be reckoned shall be excluded. Next, your lordship. In computing the period of limitation for an appeal or an application for leave to appeal or for revision or for review of a judgment, the day on which the judgment complaint of was pronounced and the time requisite for obtaining a copy of the decree, sentence or order appealed from or sought to be revised or reviewed shall be excluded. This benefit will get when the petitioner or applicant file the application for certified copy within period of limitation. But they have admittedly filed this application after period of limitation.
Okay. Yes, what is your submission?
So far the sufficient clause has been truly explained before this honorable the court, because ultimately there is a delay of 1 day if it counts, and the certified copy which was applied on 12/12 and obtained on 18, if that This, it is a delay of other 1 days, and that has court has said that part also. In trial court also has critically said the reason has been explained, the persons, there is no dispute to that part, 2 minor sons and the wife is in hospital, that was in the. Now, the thing, other part, review part will come later on, because only limitation point he has come before this honorable court, only with this misgave case, wherein the appellate court also, the trial court, he has read out, I will not go through the page number 33 again, because the court has, in the page number, let's see, that is, in the page number, lots of before, lots of kindly come to the page number 55, lots of kindly see that. That page number 55, lots of, in that he has read it, wherein court has clearly and truly explained that the everything has been properly explained before the court, the reason of delay part, because they are reside in the rural area and villagers they are only. And that has also been shown and explained that part. There is no delay, that he is delaying the process to just condone the delay. And second part, let's see kindly page number 65, let's see, come see. The appellate court has also explained everything in a paragraph number 13 to 14 also. And in that also, Lordship kind of bottom paragraph number 15, kindly read it, kindly see that. Pertinent to say that instant memorandum of appeal has been filed without supporting affidavit. So that technicality has not come to look into that part. The thing is that, Lordship, that
You are referring to paragraph number?
65, paragraph 15, Lordship. Because I rely on paragraph 13, 14, and 15, wherein court has says that exercise discretionary power and with judgment, paragraph 9 and 10, court has elaborately explained that part also, the judgment, paragraph 9, page number 63. That has also explained 65. Ultimately, there is a delay of 1 day because the certificate copy was obtained, that if that condones and 9-10 was closed, that is one. So that the ground minor sons admitted there. So now court has allowed that he approached, filed the appeal, that was rejected, and court has took that view that pertinent to say the instant memorandum of appeal has been filed without supporting affidavit. So I will not come to that part only. I see that there is a delay which has been explained. Notice that a huge delay is there, and also whatever the delay comes up, Lordship, that has been explained. So my humble submissions, the budget CRP has to be dismissed because Lineage Court has judiciously decided and elaborated, explained the proper thing that, Lordship. If that doesn't come, review petition letter will be decided on merit, Lordship.
Appellate court has also imposed cost of rupees 1,000.
Yes, Lord.
Mr. Som, what I can do is I can exempt you from payment of this cost.
Lordship.
Petition dismissed.
Yes, Lordship. There are no exceptions. That's obliged.
Lordship, I'm sorry to trouble your Lordship again. Lordship, just now I have communicated with the office of the chief engineer, Guwahati. Lordship, the budget proposal has just now received from the finance department because your Lordship is also aware the budget session is going or was going on. Only last week only it was concluded. Now the department has received the budget proposal and it has to be for activation of the budget proposal. 15 days time is required for activation. After that proposal can be sent to the finance department. So at least a month time is required, Lordship. What my department has just informed me over phone.
No,
So
unless
the department has Lordship, department has
security amount, but there shall not be any stake.
Lordship, department has also informed me over phone that within the month 30th May, the whole payment will be given to the petition. I mean, to the respondents, will be released to the respondents, provided
Then
subject to your Lordship's
you
satisfaction.
go and file an application before the trial court.
At least some observations, trial court may consider, Lordship. At least some observations. Otherwise, Lordship may see the order that is annexure 5, which I have ordered. Means this is not.
There
This
is
is
no
not
legality.
this
I
one,
am not
Lordship.
sure.
Second paragraph, learned assistant GP has not come forward to advance hearing. On 22, Lordship, she has filed an application where she has stated that the petitioner has already submitted everything, Lordship.
There is laxity and lapses on your part and also
Yes,
on the
yes,
part
it
of
is.
the government advocate.
Lordship, that is, Lordship. But some observations may kindly be granted, given at least for a month's time, Lordship. I'm not free for a long.
Okay.
Lordship. Deeply.
Madam, 17.
May please your lordship. This is the statutory first appeal lordship. My suit was partly declared lordship. Against that, I have preferred this appeal lordship, statutory appeal lordship. This is listed for first time today. I claim rupees 32 lakhs 58,000 lordship and only 2 lakhs was granted lordship.
Pardon?
My claim was 32 lakhs 58,000 lordship and only 2 lakhs was decreed lordship. Against that, I have preferred this appeal lordship. This is a statutory appeal lordship.
Third means we brought aside the Lord Council for the appellant.
Yes.
This appeal under section 96 of the Code of Civil Procedure is directed against the judgment and judgment dated 29/11/2024 and the decree dated 12/12/2024. Passed by the learned civil judge, senior division Jorhat in title suit number 60 of 2012. There is the memo of, it is to be noted here that by impugn judgment dated so and decree dated so, the learned civil judge, senior division Jorhat has decreed the suit of the
Partly decreed. Partly decreed.
Pardon?
Partly decreed the suit.
Okay. Partly decreed the suit and partly decreed the suit with cost and held that the appellant herein is entitled to a decree for recovery of rupees 2 lakhs only from the respondent sharing. And that the decretal amount shall carry interest at the rate of rupees 6%, at the rate of 6% per annum from the date of filing the suit till the date of decree. And also the future interest at the same rate from the date of decree till realization. Where is the memo of appeal and the grounds mentioned therein? Admit. Issue notice to the respondents, return evidence for which step be taken by registered post with AD and also the usual process we can respond to them. Dismissal also call for the record from the learned trial court. List the matter after 4 weeks.
Obliged.
18.
May I please your lordship? It is the first appeal against the judgment passed by the Honorable Civil Judge Senior Division, Kamru. The suit is partly allowed. It is a suit for specific performance contract, but a specific performance of contract has not been allowed. And recovery of payment amount has been allowed only. Therefore, it's partly allowed. Therefore, we heard this appeal, your lordship.
Under whose provision of law the title suit was filed? Suit was filed?
Under a specific provision of law, specific performance of contract. Suit for specific performance of contract.
Where is the plaint?
Plaint at page number 27. In page 29, that suit for specific performance contract dated and for permanent injunction.
was filed under a specific relief act 1968.
Specifically, yeah,
So you have filed this appeal,
yes.
but section 6, subsection 3 provides that no appeal shall lie.
No, no, it
from
is,
an order or decree.
your lordship, you have,
You see the act, specific relief act, section 6, subsection 3.
it is not for possession, your lordship. It is on the basis of agreement we have, it is not for recovery of possession. Section 6 is for only for death purpose. It is for specific person contract. Agreement for sale exists there. That section 6, I think it is for only recovery of possession. It is to be filed within 6 months from the date of disposition. That is not the case here. It is, there is an agreement between the parties, and for that we have.
So your pair is there, decree for recovery of possession.
After decree the suit, if suit has been decreed, in that case, court has to be executed sale deed and with the prayer of recovery of possession. If suit has been decreed, in that case only, we have that prayer is in specific ordinance contract cases, that prayer has been given. If the defendant, the landowner not execute sale deed in our favor as per court direction, in that case, court executes the sale deed on behalf of that person and also orders for recovery of possession. That's the subsequent prayer, consequential relief. That means if the, as per direction of the court, if the defendant, that is landowner, fail to execute the sale deed, in that case, court execute the sale deed and subsequently orders for recovery of possession. That prayer is given. That is not under provision 6. Only after decree the suit, your lordship. If suit has been decreed, in that case, it court directs that the defendant is to execute the sale deed with a specific period of time. If the person not execute the sale deed, in that case, we have to file execution case.
Are you sure?
Yes, your lordship. So execution case has to be filed with a prayer to execute sale deed by the court, along with for recovery of possession.
So where is the decree?
Decree at page 98. It's partly allowed, partly decreed.
But the suit is a decree in respect of the land also.
No.
A plot of land measuring 90 are covered by DUG number so and so.
That is the suit land. That is the suit land. In the judgment or in the operative part of the judgment, your lordship will.
So it was a ex parte decree.
It is the ex parte decree,
Whatever you
partly
have
allowed.
paid in your, whatever you have paid for in the plaint, that has been granted.
It is partly allowed. Actually,
Okay, you come prepared that only appeal will lie, not revision. We will fix it immediately after reopening. of the meeting. Heard Mr. H. Sisona, learning counsel for the appellant. List this matter on. On 25th of April, so as to satisfy this court that only appeal will lie, not revision petition, not revision against the judgment and decree, so passed by the learned trial court here in this.
Item 19.
Item 19, my lord, I was the defendant in title suit 66 of 2023. This suit was instituted by the respondents herein as plaintiffs. There was an agreement of sale, my lord, at Annexure 2, is 21, between me and the plaintiffs therein, my lord. Now, after a point of time, my lord, the plaintiffs sought for cancellation of the said agreement for sale, my lord. At page 18 is the prayer of the suit. What you would see, the second prayer is basically the cancellation of agreement of sale bearing date number so and so. Against that, my lord, my counterclaim is also alive. The counterclaim, my lord, seeks a specific performance of this particular agreement. The suit is alive, my lord, and this is to be decided by the trial court. But then while deciding the matter relating to injunction, my lord, Order 39 Rule 1 and 2 application, at page 51 is the operative portion which I am aggrieved by, my lord. The court only says that, my lord, I am restrained from entering the property, whereas in my opinion, my lord, when we look into the balance of convenience, since the suit property is to be preserved, a proper order ought to have been, my lord, a status quo to be maintained by both parties, my lord. It's not just restraining me. There would have been or should be since there is a counterclaim also alive against the same suit property, status quo would have been a more appropriate order, which would have struck a proper balance of convenience, my lord. So that is my limited grievance. Not against the injunction also, my lord, but then the wording of the same, my lord. I'm not against the injunction. There needs to be injunction because the suit property is in dispute. I am also claiming, he is also claiming. So a better balance of convenience would have been struck, my lord, in maintaining a status quo rather than just preventing me from entering the suit property. So that is what.
That while granting this relief, the learned trial court has discussed all the three golden principles of granting injunction.
My lord, it has been discussed, but then as I believe, my lord, when looking into the aspect of balance of convenience, my lord, the court had erred in, my lord, appreciating the fact that
Interfering with,
there is a counterclaim also alive in the suit. Only on that limited point. The suit is proceeding, my lord. The suit is proceeding.
Scope of appellate court is very, very limited.
I understand, my lord. But then balance of convenience has to be examined also in that proper perspective. The idea is to preserve the suit property, my lord. And how the suit property would be best preserved is an issue relating to
in
balance
whose
of
possession?
convenience.
So property is in whose possession?
Is in the plaintiff's position, that is the respondent's position. my lord.
Then balance of convenience is found in whose favor? then?
It is to be found in the
Certainly
circumstances.
in favor of the person who is in possession of the suit property.
Yes, but then my counterclaim relating to specific performance also has to be seen. So therefore, why I'm saying, my lord, the status quo is a better order because, my lord, would have been like my interest also on the suit property, which is a subject matter of the suit, also has to be looked into. my
Let notice go at this.
My lord, only
It's
that.
sorted.
I think we can come to a consensus, my lord, if they come, my lord.
Okay, okay.
We want only that bit modification of the sort.
Third, Mr. Pathak, learned counsel for the petitioner. And the appellant is appeal under section No, under order.
43 rule 1R.
Under order 43, rule 1R of the Code of Civil Procedure is directed against the order dated 5/11/2024 passed by the learned civil judge senior division number 3 Kamrup M in HJ case number 139 of 2023. In title suit number 66 of 2023. It is related here that by interim order dated so and so the learned trial court has restrained the petitioner hearing, no appellant hearing in taking forceful and illegal possession of the suit property and changing the nature and character of the suit land till disposal of the suit. First, the memo of appeal and the grounds mentioned therein. That made issue notice to the respondents returnable in 4 weeks. Returnable in 4 weeks. Step be taken by registered post with AD and also by legal process with a week from today. Release the matter immediately after. Release the matter after 4 weeks.
Obliged.
Timing item. 11. Sorry. My lord, this matter, my lord, the petitioner, they have taken a loan of 13 lakh odd for purchasing a housing loan for house. They have paid more than 21 lakhs. Then, my lord, in the tribunal, decree was, a certificate was issued. And in spite of there being a stay order, recovery officer issued for issuance of, my lord, property details and all those things. So that order has been challenged. It is under stay. Now, in the meantime, we have submitted this office. It has moved from Guwahati. There is no local office. No one is there. The one person I am told he perhaps looks after some clerical things. Now we have issued a, my lord, OTS proposal in the address. It came back. So subsequently, we have submitted another OTS proposal before the recovery officer. Now, my learned friend, my lord, this is a copy. I have also given a copy. My lord, in the month. Another OTS proposal, my lord, we have given on, my lord, February. So I have given a copy to my learned friend. So whether it is acceptable to them or not, they should, my lord, what amount is acceptable? Because these petitioners, my lord, from 2000, I think, 10 is fighting this litigation, took a loan of 13 lakhs in 2010 for purchasing a house. And he has been depositing this amount also before the tribunal from time to time. So, my lord, let my learned friend bring an instruction whether this is acceptable to them or not.
Yes, sir. I'll take inspections on that.
We will take inspections. Because also we also want to pay off the money and get rid of the litigation, and they are also interested in money.
What is the outstanding amount now?
Outstanding as per the, my lord, certificate of the tribunal has directed to calculate interest at the 10%. Now they have what they have calculated, they have, that is an affidavit. As per that their calculation, it comes to 23 lakhs. As per our calculation, it comes to 13 lakhs odd amount, my lord. So in calculation also, so if this is not settled, my lord, then we'll pray to the court that independent chartered accountant be appointed. He will calculate and submit a report, my lord, in that case.
Your lordship, in the event of the recovery certificate has been issued
there is no scope for, because it is just a simple calculations matter.
No, no,
So
there
however, they have
cannot-
made a proposal to us, so we
Yes.
will take the decisions accordingly.
Hmm.
But once the certificate has been issued, that means every matter has been settled.
But that
They have to
calculation
go
has
by
to
the
be, my lord,
certificates only.
calculation has to be correct, my lord.
But
There
has-
cannot be, because the calculate, the CA has
And they
made
are
a
not
calculation.
disputing the calculation. They are just want the settlement. And
Hmm.
settlement cannot be claimed as a matter of rights.
We have given, let them say they are not agreeable, then this question of, my lord, calculation of interest will come, because
For that, I am seeking
Yes.
some time to get the instruction.
let them obtain an instruction. And the problem is that there is no office here, that we could go and communicate with the officials. So it has to be sent through post. Their address also keeps on changing. Last time it was sent, it came, this proposal was returned. So let them say what they have to say on this. It was sent on February 25, my lord.
You are for all the respondents.
Yes, your lordship. No, I am for the
Alright.
assets reconstructions.
He's respondent number 3, my lord.
I'm responding number
Respondent number 3.
Because earlier the loan was taken from the State Bank of India, and later on under section 5 of the Surface Act, it has been assigned to us. And we have already substituted in the records of the learned DRT below. And thereafter we are pursuing the case.
So he is the main person, respondent number 3, my lord.
I am 3, your lordship. Yes.
And who is for rest of the respondent?
Respondent?
This is
Who represents the rest of the respondents?
Your
One,
lordship,
two, and four?
number 4 is the K. Mukherjee. He has already transferred it.
He, after receipt of notice, he has not appeared, my lord.
Okay.
Notice was served.
Then
And
one and two?
1 and 2 CGSC, my lord, I think.
CGC.
In the cause list, my lord, it says, yes. CGSC, assistant SGI. They are formal parties, my lord.
They are not
Formal
required
parties.
as.
Mr. Sharma is the main, my lord, person.
Third, Mr. Edas, learned counsel for the petitioner, and Mr. Sharma for the respondent number 3. Then it is for the respondent number 1, 2, and 4. Mr. Das, learned counsel for the petitioner, submits that petitioner has submitted a proposal to the respondent number 3. Respondent number 3. When you have submitted this proposal?
27 to
25. Have you received it?
Your lordship, I have received just now, but they are submitting that they have already posted the
Yes,
to the copy.
it was sent
The
through
central office.
my lord, speed
And
post.
sent to the official address of the respondent number 3. And also furnish a copy of the same to Mr. Sharma. And Mr. Das submits that necessary direction may be issued to the council for the respondent number 3 to obtain instruction in respect of the aforementioned proposal. Mr. Sharma submits that he will obtain necessary instruction. Then apprise the same before this court on next day. List the matter on second of May.
Timing item 15.
Please, your lord.
Your Lordship, I have not yet received the brief from the parties. After filing of the Wakalatnama, I have not received the briefs till date. And all my process to communicate them has been finished. A short date may be given.
My lord, the problem is that, my lord, next date is fixed on 9th, my lord, and there is no stay order, my lord. The court is not, court is already proceeding with the proceeding, my lord. So,
Fill an application.
my lord, we have already filed, my lord, at least, my lord, till next date, my lord, to stay order maybe, my lord. The lordship has already passed the order that, my lord, after their appearance, my lord, pair of stay may be considered, my lord. At least, my lord, next date,
Yes,
my lord, till next date, my lord.
That can be done.
Where is that order?
That first order, my lord, of admission, my lord.
Third, Mr. P. Sundri, learned counsel for the petition. And Mr.
Amar Sodial.
M.R. Sodial, Learned Counsel for the respondent. How many respondents are there? Both the respondents?
Yes.
For both the respondents. Mr. Sodial submits that he has not received any instruction from the respondent number 1 and 2 and as for listing the matter after a week. It is accordingly allowed to list the matter after a week. Mr. Sompi submits that. The next date is fixed. In the trial court on
9/4, my lord.
9/4. And as such, there is a requirement for staying the impugned order dated 16/12/2023.
Stay the proceeding will suffice, my lord, till next statement. Proceeding before the trial court, my lord.
Equal matter. And another order dated 9/5/2024. And no, there is a requirement for staying further proceeding of the PS case number 15, which will make it K 2014, pending before the Court of Learned Civil Judge no doubt till next day. The Learned Counsel for the respondent submits that he has no objection in the event of staying the proceeding till next date. Accordingly, taking note of the submission of Learned Counsel to both the parties, further proceeding of PS case number 15, which will make it K 2014 stands stayed till next date. Is the matter on second of
My lord.
deep knowledge.
Much obliged.
One more respondent is there.
My lord, all are, my lord, relatives, my lord. Tinta respondent.
I'm for 1 and 2. 1 and 2. Whether notice was served upon the third respondent.
Number 1 is the
Okay,
wife, my lord,
always
other than son, daughter.
Your
my
name is shown against all the 3 respondents.
And I have to clarify.
Okay. Next day.
Yes.
Item 20.
May it please your lordship.
Yes.
Lordship, this is a matrimonial appeal under section 55 of the Indian Divorce Act, lordship, against the judgment and order passed by the district judge.
Okay.
21.
Appeal, my lord. It is an MSc appeal for enhancement.
Third, Mr. A. Bhattacharya, Learned Counsel for the appellant. This appeal under section 173 of the MD Act is directed against the judgment and award dated 10/2/2025. Passed by the learned member MSCT, Motor Accident Claim Tribunal number 2, which would make it MSCT. Kamrup and Guwahati in MSC case number 2769 of 2019. It is to be noted here that by the judgment and award dated so. The learned tribunal has directed the appellant to pay a sum of rupees 32 lakhs 19,107.97 rupees as compensation to the respondent. Respondent number?
Directing insurance company, respond number 3.
No.
I'm the claimant. I'm the claimant, man.
You are the claimant.
We have come for enhanced.
Vivas Bora or Bhoben Bora?
Bhoben Bora.
To the appellant hearing. To the appellant hearing. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the interim judgment and award dated 10/2/2025. Admit issue notice to the respondents returnable in 4 weeks. That be taken by registered post with PD and also by usual process. We can respond to that. Dismissal call for the record from the learned tribunal. This is the matter after 4 weeks.
Public.
20. Well, in this case, the compensation was declined to grant on the ground that the boy who drove the vehicle it is 17 years old. It's a minor matter. On the other hand, other case, my lord, he is also driving the same motorcycle, another motorcycle, 17 years in the same series of accident, has been granted 7 lakhs rupees. But to be paid by the owner. But my prayer, first case, my lord, the notice will be issued only. And second case also notice, my lord. There is a.
The second is
There is a amount has been granted, my lord, 7 lakhs. But I have prayed for enhancement as well as it should be pay and recover from the insurance company. Pay and recover from the owner.
so in the first case, your
Only
claim was,
notice, only
dismissed.
notice, my lord.
Heard Mr. Biswas, learned counsel for the appellant. This appeal under section 173 of the NDA is directed against the judgment and award dated 10/2/2025. Hospital learned member motor accident claim tribunal, City. Kazolgaon, Sriram Kazolgaon in MSC case number MSC, date case number 11 of 2023. It is to be noted here that by the judgment and award dated so the learned tribunal has dismissed the claim of the petitioner. No, claim of the appellant herein. There is the memo of appeal and the grounds mentioned therein. Admit issue notice to the respondents returnable in 4 weeks. That be taken by registered post with AD and also by usual process. We can work to the Dismissal call for the record from the learned tribunal. Is that a 4 weeks? Second is arising out of the same accident.
Yes, yes, ma'am.
Third is the SC Biswas, learned counsel for the appellant. This appeal under section 173 of the NDA is directed against the judgment and award dated 10/2/2025 passed by the learned member MSC Sriram Kazolgaon in MSC, date case number 12 of 2023. It is to be indicated here that by the team judgment and award dated so the learned tribunal has directed the respondent number 1 herein. So insurance company was directed to pay.
Yes,
Respondent number 1.
yes.
No, from the OP number 3. OP number 3 is the
Open number 3 is the owner motorcycle.
owner. Then why you were submitting that the insurance company?
No, what has been given against the owner?
Respondent number 3.
Yes.
To pay a sum of rupees 5,73,000 within a period of with interest at the rate of 6% per annum from the date of filing the claim application. You know, receipt of the award. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated. Then to 2025. Admit issue notice to the respondents, create an equivalent for weeks, that be taken by registered post will be in also by legal process. Okay. This is a call for the record, the learned tribunal is the matter of the 4 weeks.
24.
May it please your lordship. The appeal lordship we have filed because the tribunal came to a finding that the insurance company is not liable, but then asked for pay and recovery lordship. As per the new amended act, there is no question of pay and recovery.
No?
No pay and recovery, that is deleted from the new act. And earlier also, if it has to be pay and recovery, then Nanjappan case is to be followed lordship, that the owner will give the security and then the amount.
No, when the accident took place?
Accident took place in 2014.
14, the claim was under old act.
Yes. If it is under
Then the
old act,
new act can be retrospectively given effect.
judgment was passed in 24.
Maybe.
And even if lordship, if we go by the old act, then also Nanjappan case is to be followed. So that way also. At this moment, we can deposit 50%, lordship can admit, and then this may be decided. We
What
have
is
a
the
I
amount?
also.
Awarded amount is 1,55,000.
One second, 55,738.
Or Miss Ardas?
And Mujum, that's Mujum.
Or the Mazumdar learned counsel for the appellant. This appeal under section 173 of the MD Act is directed against the judgment and award dated 3/4/2024 passed by the learned member, motor accident claim tribunal number 1, Kamrup and Guwahati, in MRT case number 828 of 2016. Is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant hearing to pay a sum of rupees 1,55,738 rupees only.
9% interest.
With interest at the rate of 9% per annum from the date of filing the claim petition, that is 20th/4/2016 till its realization. Peruse the memo of appeal and the grounds mentioned here. And also peruse the judgment and award dated so and so. Admit issue notice to the respondent, returnable in 4 weeks, subject taken by registered post with within also by usual process. Come to that. Dismissal call for the record, please the matter after 4 weeks. Madam, this amount is not so exorbitant that the company will not be able to pay.
No, company can pay lordship, but then.
But see, madam, if the matter remains pending before this board.
Okay, lordship, we can deposit with the interest also, but release till they appear, lordship, release may not be allowed. Let them, when they appear, let them file a petition. Lordship can direct us to deposit the amount along with the interest, so that at least we are not burdened with any more interest. But during COVID period, that also we have taken, Apex Court had ordered that there will not be any interest on COVID period. During COVID period. Anyway, lordship, since the amount is very less, can deposit the entire amount.
Separate for IA.
IA 1058.
Harkness R.D. Mazumdar, learned counsel for the applicant. This interlocutory application is prepared by the applicant for staying operation of the impugned judgment and award dated 3/4/2024, passed by the learned member, Motor Accident Claim Tribunal, number 1, Kamrup and Guwahati, in MC case number 8/28/2016, till disposal of the appeal. Ms. Mazumdar, learned counsel for the applicant, submits that the applicant has already prepared one appeal under section 173 against the impugned judgment and award, and the same has already been admitted by this court, and the record has also been called for, and as such, there is a requirement for staying of the impugned judgment and award dated 3/4/2024 till disposal of the item. And that the applicant is ready to.
No, Lordship, not ready. Lordship will direct us to. Not ready. Otherwise, what is the use of my appeal? Lordship can direct us as a condition for stay.
Since the appeal has already been admitted and the record has also been called for, the impugned order dated impugned judgment and award dated 3/4/2024 stands state till disposal appeal. However, subject to subject to deposit of the entire amount of compensation with interest before the registry of this court within a period of
6 weeks.
no.
Lordship, Bihu holidays are coming.
3 weeks. Within a period of 3 weeks.
Obliged, Lordship.
I stands close.
26.
April. Is an appeal for enhancement. Appeal by the claimant.
Death case or
Injury
case?
Injury case, man.
What is the amount you have received?
No, my lord, seven,
Seven?
my lord, total awarded amount, my lord, 8,75,193.
Heard Mr. Partasese, learned counsel for the appellant. This appeal under section 173 of the MD Act is directed against the judgment award dated 4/1/2025, passed by the learned member, Motor Accident Claim Tribunal number 1, Kamrup and Guwahati. Tribunal number 2, Kamrup and Guwahati, in MSC case number 5/22 of 2020.
21. There is a typographical error. We have moved one application for correction that is allowed. That
When?
order I have already
When?
enacted.
Is it part of the record?
Yes, yes. This
Page
page
number?
33.
Page number?
Page 33.
Okay. 2020. Is to be noted here that by impugned judgment and award dated so and so, the learned tribunal has directed the respondent insurance company. Respondent number?
1.
Respondent number 1. NS IFCO Tokyo General Insurance Company Limited to pay a sum of rupees 8,75,193.50 rupees being a compensation with interest at the rate of 9%. From the date of claim petition.
Yes.
That is 15/3/2021 till the date of payment in favor of the claim. Where is the memo of appeal and the grounds mentioned herein? Admit issue notice to the respondents returning for stability by registered post will be given also by usual process within our come to this. Recessal call for the record. This is the matter of the forings.
27.
Here also, my lord. It's an appeal for enhancement by the claimant.
Is it a death case or injury case?
Injury case, my lord.
What was the amount?
Amount is 22,29,400.
On what ground you are preparing this appeal?
My lord, there was an amputation of his right leg, my lord. But that aspect, there is a 90% disability that is being pleaded and proved by the claimant, but only 70% was allowed to be given. So that is the
There may be in the disability certificate, though it may be mentioned, yet the court has the power to assess your
Yes,
loss of income
absolutely, my
also.
lord.
And
My argument would
whether
be
that 90% is related to
his
whole
income.
body.
Yes, no. That in respect of the that his lower part of the body. But we have adduced evidence that since the petitioner was a businessman, for the purpose of his business, it will hamper his function. My lord. So therefore, for the assessing the functional disability, it should have been 100%, my lord, because he cannot move.
What kind of business he has been doing?
My lord, he is doing the that I have stated.
Or Mr. Reporter learned to product. This appeal under section 173, it is directed against the judgment award dated that 1/2025. Hospital learned member MSC number 3 Kamrupem Guwahati. In MSC case number 127 of 2019. It is to be noted here that by reviewing judgment and award dated so the learned tribunal has directed the respondent number 3.
Yes.
Respondent number 3, that is MS Oriental Insurance Company Limited, to pay a sum of rupees 22,29,400 rupees, paying the compensation with interest at the rate of 6% per annum from the date of filing the claim petition till its realization. Where is the memo of appeal and the grounds mentioned there? Also, where is the judgment and award dated? Admit issue notice to the respondents regarding the forage that be taken by registered post 88 minutes of legal process. This is the call for the record from the learned tribunal. It's the matter of the forage.
For hearing under order 41, go to CPC 28. Lordship, this is an appeal under section 58 of the Real Estate Development and Regulation Act 2016, Lordship. And Lordship, the appellate judgment, Lordship will find at page 421, Lordship. This is the appellate judgment. What happened, Lordship, in this case, the appellant before this honorable court was the complainant. And the Real Estate Regulatory Authority has allowed the case of the complainant therein. However, the respondent has challenged the same before the Real Estate Appellate Authority. Out of the 9 numbers of complaint, Lordship, only one complaint was reversed by the learned appellate tribunal. I am against that reversal order, Lordship. If your Lordship permits me, may I go to the finding of that particular complaint, Lordship? Lordship will find that complaint, finding of that complaint at Lordship page 426, Lordship. That was the complaint number 4.
Page number 400?
426, Lordship, internal page 6, Lordship, of the judgment. Internal page 6, 426. Lordship, got it, Lordship. And below, Lordship. Four 26, Lordship. Clause number 7, Lordship, below, Lordship. Complaint number 4, inability of the respondent to give lawful possession to the complainant. Mary, Lordship. Finding of the RERA. RERA has stated that as per provision of section 11B of the Guwahati Construction Regulation 2010, the applicant is considered to have received the deemed occupancy certificate after expiry of 21 days, provided the building has been constructed as per the approved plan. RTI replies dated such and such, and the subsequent correspondence dated 23/2021 and 3/11/21 addressed to the builder by the GMDA indicates that the builder did not adhere to the sanction plan as approved by the GMDA. Therefore, presumption that the builder has received the deemed occupancy certificate is misconceived. The RERA has also observed that the promoter cannot give possession of the apartment without receiving the occupancy certificate as adjoined by clause 7.2 of the model form of the agreement prescribed under Rule 9 of the rules and section 11(4)(b) and section 17 of the Act. RERA has concluded that in this instance case, the act of issuing possession certificate to the complainant by letter dated 20th/11/19 is in violation of section 11(4)(b) and 1910 of the Act. Read with clause 7.2 of the Annexure A prescribed under Rule 9 of the rules. The builder is therefore liable to be penalized under section 61 of the Act. RERA has ordered that the builder has obtained occupancy certificate from shall obtain occupancy certificate from the GMDA by complying with all the direction issued by it by the GMDA. Further, the builder shall hand over the authenticated copy of all the relevant documents, the NOC issued by the competent authority, completion certificate, occupancy certificate, sanction plan, and hand over lawful possession of the villa to the respondent complainant by completing all the required formality as per provision of law. RERA has also stated that the respondent complainant are entitled to get interest from the builder at the rate of SBI marginal rate of lending plus 2% of at rupee 1.5 crores with effect from 28/8/2020 for every month of delay till the lawful handing over possession of the villa to them as per provision of section 18(1) of the Act. This was the finding of the RERA. Now, what REAT has said, Lordship, 7.2. The appellant has argued that possession of the villa by the respondent is valid possession, which was handed over to them only upon their insistence. It is argued that the respondent, on one hand, have taken possession of the villa and is enjoying the same, and on the other hand, is claiming compensation on the ground that the act of giving the said possession was not lawful. In this connection, the appellant has relied upon the judgment of Apex Court such and such, wherein in paragraph number such and such, the Apex Court has held that a person is not permitted to appropriate or reprobate, that is only rely on a particular transaction to obtain some benefit on the basis of the said transaction is valid, and on the same breath challenge the said transaction containing the same is deemed to be unlawful. The appellant has argued that the respondent, knowing fully well of the status of the occupancy certificate and the stage of construction, had taken for approach for possession, and after taking possession, they are now trying to take advantage. The appellant has further stated that clause 9 of the NOC for construction dated such and such indicates that if the authority fails to issue occupancy certificate within 2 weeks from the date of the application for occupancy certificate, there would be no bar for occupying the said building. It is contended that in view of the such stipulation, it cannot be said that the possession given to the respondent is unlawful. The appellant has stated that RERA, while directing payment of interest, has purportedly relied upon the proviso of section 18(1) of the RERA Act, although the statute nowhere uses the word or phrase lawful possession. Section 18 provides for handing over of possession in terms of agreement for sale, and only on failure to do so, the proviso would come into force. In the present case, the appellant was required to hand over possession within 2 years from the date of the agreement, that is on or before 26/8/2020, and possession admittedly was handed over on 28/11/2019. Therefore, the appellant has asserted that the insertion of the word lawful by RERA is bad in law. It is seen that clause 7.2 of Annexure A being model form of agreement prescribed under Rule 9 of the rules provides as follows. The promoter, upon obtaining the occupancy certificate from the competent authority, shall offer in writing the possession of the apartment plot to the allotee in terms of the agreement to be taken within 3 months from the date of issue of such notice, and the promoter shall give possession of the apartment plot to the allotee. The promoter agrees and undertakes to indemnify the allotee in case of failure to fulfillment of any provisions, formalities, documentation on the part of the promoter. Section 1910 of the Act provides that every allotee shall take physical possession of the apartment plot or building as the case may be within a period of 2 months of the occupancy certificate issued for the valid said apartment plot or building as the case may be. Section 11(4)(b) of the Act specifies that the promoter shall be responsible to obtain the completion certificate or occupancy certificate or both as applicable from the relevant competent authority as per local law or other law for the time being in force, and to make it available to the allottees individually or to the association of allottees as the case may be. Section 1910 of the Act and clause 7.2 of the annexure under Rule 9 of the rules make it clear that prior to offering possession, the promoter must obtain occupancy certificate from the competent authority. In this case, the possession was offered to the complainant respondent without occupancy certificate. That finding is there. Having been obtained in the first place, truly the possession of the villa was not strictly as per mandate. On this, we would observe that although the possession of the villa given to the respondent complainant was without the occupancy certificate being in place, the fact of taking possession of the villa by the respondent complainant is not disputed. For the act of not having obtained the occupancy certificate prior to handing over the possession of the villa, in our considered opinion, the builder could have been penalized under Section 61 of the Act instead of being imposed with payment of interest. Having regard to the peculiar facts and circumstances of the case, the imposition of interest as ordered by RERA was unwarranted. We therefore interfere and set aside the direction of RERA imposing interest upon the appellant against complaint number 4. Liberty is given to the respondent complainant, if so advised, to approach RERA for invoking provision of Section 61 of the Act. The appellant is aggrieved by this part of the order, Lordship. Because admittedly, Lordship, the appellate authority has came to a finding that the possession was not as per mandate, Lordship. And Lordship, to appreciate further, Lordship, may pay your Lordship to Lordship, may peruse page 30 for a minute, Lordship. Page 430, Lordship, 430. Small finding, Lordship. Internal page 10, Lordship, of the judgment. Internal page 10, Lordship. Lordship.
413.
430, Lordship.
430. Yes.
Finding of the REIT in respect of complaint number 6, Lordship. Below, Lordship, clause number 9, Lordship. Complaint number 6, failure to transfer the title of common area by the respondent to the society as per sanction plan approved by the GMDA. The finding of RERA. RERA has observed that the appellant builder has not yet obtained the occupancy certificate. Till that occupancy certificate is not, till now is not there, which is a vital document to effect the transfer of title to the allottees and to the association of allottees. Hence, the appellant has not yet transferred the common areas of the project as per sanction plan to the area Smart Living Housing Cooperative Society by executing a registered deed of conveyance deed as enjoined under Section 11(4)(f) and Section 17(1) of the Act. In its order, the RERA has asked the builder to transfer the title of common area of the project of the area such and such limited as per sanction plan approved by the competent authority within 3 months of issue of the occupancy certificate by the competent authority as per provision of Section 17(1) of the Act. Further, the builder shall also hand over the relevant documents relating to the project to the society as per provision of section 17(2) of the Act. The builder has been directed to declare in writing the detail of the common area and free space arising out of the sanctioned plan and indicate the present status of the ownership. Now, finding of the REIT lordship. On behalf of the appellant, it is argued that section 17 of the RERA Act does not provide that possession of the property is required to be handed over within specific period after obtaining occupancy certificate. The specific language of this section is that physical possession is to be handed over within the specified period as provided under the local laws. The time period of 3 months from the date of issuance of occupancy certificate is mentioned in the proviso of section 17(1), that is only in absence of a local law. It is submitted that there is a local law governing the transfer of immovable property in the state of Assam, and the said law does not require the grant of occupancy certificate for sale of land and villa. At the outset, we hold that the appellant's argument cannot be accepted if local law does not provide any time limit as argued by the appellant. The time limit prescribed in section 17(1) will be applicable in the instant case. Similarly, it cannot be argued that no occupancy certificate is required for transfer of title because the local law does not require the builder to do so. Therefore, the finding of the RERA, so far complaint number 6 is concerned, are upheld. Lordship, I've read this because to show before this honorable court that the common areas of the project has yet not been transferred either to the society of the allottees or to the individual allottees of the project, lordship, which has been specifically provided in the agreement, lordship. If your lordship goes to the agreement to sell entered into.
No, we are not finally hearing the matter.
Lordship, only for admission, lordship.
Yes. What more is required?
Lordship, only.
So you are agreed by finding of the
complaint number 4, lordship.
Complaint number 4.
Lordship. At page 426, lordship. Only lordship, 58 is lordship prescribed for section 100 CPC, lordship.
Pardon?
Second appeal, lordship.
Second appeal.
Second appeal. Because complaint.
In order to admit second appeal, we have to formulate substantial.
Lordship,
where you have mentioned it?
Lordship, I have mentioned, lordship, I have given the memo. Lordship, para 4 from para 4 of the memo of appeal, lordship. Para 4 of the memo, the substitution of law.
So this is the only substantial question of law to be framed by this court.
Lordship.
This para number 4.
Para number, no, page 4, lordship. Page 4 of memo of appeal, lordship. I've given the draft substantial question of law, lordship. Para number, page 4 of.
Substantial question of law are in page number 5.
5, lordship, 7, serial number 7, 8, and 9, 10, lordship. Total 10, I've drafted, I've given draft substantial question of law, 1 to 10, lordship.
Which one are important?
Lordship, lordship, what I'll be submitting, 2 may be important, lordship, 2, 4, 6, lordship, lordship. 2, 4, lordship, 6 is important, lordship, and 10, lordship.
No, whether all those finding, all those substantial question of law relates to
complaint
finding in respect of complaint number 4.
Yes, lordship. If your lordship peruse section 18 of the act for a minute, lordship. only the,
Okay.
okay, I've given the. Section 18, Lordship. It relates to complaint number 4, Lordship.
Section
18, 1/8, Lordship. Because the learned Riet has denied me the interest, Lordship. Riet has only denied me the interest for delayed delivery of possession. Here, section 18 is prescribed for that, Lordship. Lordship, got it, Lordship.
return of amount.
Lordship, return of amount and compensation, Lordship.
Yes.
I'm reading, Lordship. If the promoter fails to complete or is unable to give possession of an apartment, plot, or building in Lordship, in accordance with the terms of the agreemental sale, or as the case may be, duly completed by the date specified therein, Lordship. This is the only I require this, Lordship. Because the possession should be as per the agreement to sell duly completed. And apparently I have shown before this honorable court, there is no occupancy certificate till now, Lordship. And why it's not as per agreement, Lordship? That, Lordship, I wanted to show, because the agreement says the common areas to be transferred to the society or to the individual buyer. And as I read, Lordship, as per finding of the complaint number 6, the common areas till date has not been transferred to the either to the society or to the individual buyers, Lordship.
So you were referring to question number 2,
6,
4,
2, 4, 6,
and 10.
6, Lordship, 6 will be required because there is 6,
Yes,
18.
6 and 10.
Lordship.
No, is there any requirement for framing of substantial question of law
Lordship.
as per this act?
Yes, Lordship, may peruse section 58, Lordship.
58.
58. Appeal to the High Court, Lordship.
Yes.
Lordship. Appeal to High Court, Lordship. Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the High Court within a period of 60 days from the date of communication of the decision or order of the appellate tribunal to him or any one of more grounds specified in section 800 of the Code of Civil Procedure, section 100, Lordship.
Court Mr. S. Appropriate, Learned Counsel for the appellant. This appeal under section 58 of the Real Estate Patent and Regulation and Development Act 2016 is directed against the judgment and order dated 11/4/2023 passed by the Assam Real Estate Appellate Tribunal in REAT capital stroke Assam stroke appeal number 12 of 2022. And the judgment and order dated 11/4/2023 passed by the Assam Real Estate Appellate Tribunal in REAT stroke Assam appeal number 12 of 2022. Allowing the we were repeating the same thing in the post title.
Lordship, the appeal number is 12 of 22, Lordship.
Yes. For sending the order. For Now reversing the order dated 21/9/2022 passed by the Real Estate Regulatory Authority. In the case number Assam RERA, Assam stock RERA stock com stock 2020 stock 08 stock 2711. Whereby the Real Estate Regulatory Authority has allowed that complaint number 4 in favor of the appellant struck defendant. There is the memo of appeal and the grounds mentioned therein, and also there is the interim judgment and order dated 11/4/2023 passed by the Assam Real Estate Appellate Tribunal in read stroke Assam stroke appeal number 12 of 2022. This appeal is admitted on the following substantial question of law. It's case number 5, question number 2, 4, and 6, and 10. Issue notice to the respondents returnable in 4 weeks. Step be taken by registered post which ABM also by usual process within a week of today. Recessal call for the record from the learned authority. Learned tribunal. Please the matter after 4 weeks. Is there any IA?
No, IA, Lordship. What happened, Lordship? They have also filed an appeal, Lordship.
Okay.
Pending item 45 for motion.
Made to the watch. There is a caveat. The respondents are appearing by way of caveat. Well, the issue here is the temporary injunction. The respondents filed the suit. I'll just give the facts in a gist. They filed a suit for declaration that the ad hoc committee, which was formed in the meanwhile for management of the Batadraba Than, that is illegal. And they want a further decree that the committee which was existing, which was elected earlier, that was dissolved by resolution in the second annual general meeting. That resolution should be declared as illegal and void, and there should be an injunction restraining the defendant, that is the committee members, from functioning. Initially, there was an order of injunction, temporary injunction, that was put to challenge here. This court, and then that was put to challenge in appeal. Appellate court interfered with. They came here. This court remanded the matter back, and thereupon it was finally decided granting temporary injunction. Now, Lordship will kindly see here. First, few things I would like to place. How the whole consideration has been made in a case of given measure. Lordship will kindly take up first the page, that English translation. No, let me take your Lordship first to the order dated 23/9/24, that is passed by the trial court issuing injunction.
Page number.
Page number 85, it starts. And I will invite your lordship's attention to page 96 up onwards. Lordship will find, see. Kindly come to page 96.
Yes.
Third para, my lord. However, it is a subtle principle that once due election process has commenced, it is not permissible to stop the same midway. Now, fact remains that this long 2 years back election held and they were functioning. The committee was there because of the malfunctioning of the committee. There was a no trust motion against them in the annual general meeting, and that annual general meeting resolved to resolving that and forming a new committee. The court has gone to the extent of this, that it is not permissible to stop the same midway. The whole consideration has gone astray. In the instant case, Sri Sri Botordaba Than Management Committee headed by the petitioners who were duly elected in the triennial general meeting held in the month of May 2022 for a term of 3 years as per the constitution of Sri Sri Botordaba Than, and that the tenure of the petitioners committee would come to an end on 15th May 2025. I will deal it later on. There is no such specific date pleaded by them. The resolution of the duly elected body of the petitioners would amount to indirectly, kindly see, the dissolution of the duly elected body of the petitioners would amount to indirectly setting aside the earlier election. And such power is not conferred by the constitution of Sri Sri Botordaba Than. Entirely wrong approach. So long as the election is not declared invalid in the manner known to law, the dissolution of the duly elected body of the petitioners should not have happened. As if I am challenging the election. Totally, but not a consideration which goes away from the main issue. I am challenging what? I am not challenging their filing a suit that my committee, which has been now selected, constituted for going into the details and to hold the next general meeting for election of a new committee and dissolving the existing committee because of some malfunctioning. They wanted that my committee should be declared as illegal and their committee dissolution should be declared as illegal. So fact remains that the committee has already been dissolved. We are not on the election. Now, further, it is the contention of the opposite parties that the president of the Than Parichalana Committee was not authorized by the general members of the to file the suit or defend the suit. These are there. I will take your lordship little later, but first the consideration on factual part I will take later on. Kindly skip these pages and come to page 97. 97. I have already read 97, that part. And then kindly come to page 101. Discussing all that regarding registration, this and that, whether registration was there. I am not going to all that. Last few lines of page 101. However, let me read the paragraph from the just few lines above. In the instant case, it is stated by the petitioners that the petitioner society was registered under the Societies Registration Act, so and so. Once the society became a society registered under the said act, all the consequences arising thereunder shall ensue. It is the contention of the opposite parties that the ad hoc committee with opposite party number 1 as president was formed in the general meeting of the Botordaba Than Parichalana Committee held on 9/6/2024 for a period of 6 months only to inquire about the corruption charge and financial irregularities by the office bearers of this committee. However, the constitution of Sri Sri Botordaba Than does not provide for formation of any ad hoc committee. Well, that is always permissible in such situations. Further, in the event that the society,
Whether that constitution is part of the record,
sorry,
that constitution is part of the.
yes, yes, yes. This constitution is a part of the record.
Okay.
The committee became defunct or other statutory requirements were not complied with by the members of the society, penal measures could have been taken. But in no situation, the elected body could have been dissolved because there was no registration. Registration lapsed long ago. Therefore, it is no longer a registered society. Therefore, it cannot claim protection under the law. And then the question of filing a suit would be, again, has to be by the whole members. How they have filed the suit? Suit itself is defective. I will point it out later on. Suit itself is defective. It is only for
When this registration elapsed,
registration elapsed on this, it is there. Registration elapsed. I'm giving the date, Mala. আমার W সূত্র আছে।
It is renewed. It is renewed. It is renewed. There is no lapse.
When?
So that document I can bring.
No, that was later on brought in, but at the time of, if it was done, only recently that could have been done, not that time. It was not there. I am giving the date. I will give the date, my lord, let them find out. I'll take your lordship to the further considerations. Page 101, I was reading. And 102 then. Measures could have been taken, but in no situation the elected body could have been dissolved. It is only for the statutory authorities and not for any ad hoc committee to take recourse to such actions as are provided for in the Societies Registration Act 1860 or the rules framed thereunder. It is not the case of the opposite parties that the bylaws of the petitioner society or the constitution of Sri Sri Bhattacharya Than are invalid in law. Once a valid election was held, that could not have been set aside. This is the finding, my lord. Further, as pointed out by the petitioners, that although the opposite parties has stated that the petitioner society has not renewed its registration and it has ceased to be a registered society, the fact remains that the ad hoc body formed by the opposite parties has put the same registration number as that of the petitioners. There is therefore no reason as to why the elected members of the petitioners should not be allowed to carry on the activities of the society. That is the approach of the court, leaving aside the other considerations. Herein, it can be seen that the plaintiff's petitioners has made out a case in his favor of going into trial, and apparently the balance of convenience thus seems to lie in favor of the plaintiff. That is a sweeping finding, my lord. There is also a scale which shows that the opposite parties, by dissolving the duly elected committee of the Sri Sri Bhattacharya Than before the expiry of its tenure, has violated the constitution of Sri Sri Bhattacharya Than and has accordingly harm the reputation of Sri Sri Bhattacharya Bhattan. Well, the finding arrived at which is totally perverse and which is extraneous. So, keeping in mind the facts and circumstances involved in the case, and in view of the discussions made above, and also as to avoid diverse and prolonged litigation, the opposite parties, defendants, and their men, agents, etc., are restrained from interfering in the daily works as well as performing the duties of Sri Sri Bhattacharya Bhattan Porichalana Samiti till the disposal of the suit. Kindly note, till the disposal of the suit. But this committee itself says they have a tenure up to May 25, 26. No, May 25, May 25. That court says the disposal of the suit. The opposite parties, defendants and their man agents, etc., are also restrained from interfering in the cash transactions of Sri Sri Bhattacharya Bhattan Porichalana Samiti. Further, the opposite parties, defendants and their man agents, etc., are prevented till the disposal of the suit from doing any activities that would harm the reputation of Sri Sri Bhattacharya Bhattan, accordingly disposed of. Now, what about balance of convenience, irreparable loss, prima facie case?
No, balance of convenience, the court has discussed.
Because there is a case to be gone into.
Yes.
That is why balance is there.
Yes.
But is it sufficient to say? Kindly see. They have a prima facie case, so balance of convenience in there. What is the balance of convenience? What irreparable loss will be suffered by them? Kindly see who has filed the suit. Now I will take your lordship to the plain. Who has filed the suit? Two persons. One claims that I am the president. One claims I am the working president. No one. They have not divulged the name of the secretary, not the other members. Nothing. And fact remains, my lord, here's a case where the committee has already been dissolved, they admit. That is why they want a decree that dissolution is bad. When the committee has plaintiff is already dissolved, can it be revived by an injunction awaiting a finding on that, whether this is entitled to be revived, holding that the action was illegal? This is a question of law. Kindly see, what is their plaint? What is their plaint? They wanted a decree. Page 23, lordship will find 22, Annex 1.
On the date of filing.
At page 22, lordship will find Sri Sri Bhattacharya Bhattan Management Samiti, so and so, represented by Sri so and so, Sri Sri Bhattacharya Bhattan Management Committee, Bhattacharya, so and so. This is the first number one. Number two, so and so, one person, he is the executive president of so and so. And see the defendants, they are by name persons, not the committee as such. They want a dissolution of the committee which has been formed. But that committee as such is not a made party. Two individuals, Viraj, he is the president of that committee. He has been made a party, and Soilian Soikia, next one, secretary. But what is the committee? What is their prayer? Kindly see. At page 30, lordship will find 29. Oh, a decree declaring that Sri Sri Bhattacharya Bhattan Management Committee headed by the plaintiffs will continue to discharge its duties and function till its tenure comes to an end on 15th May 2025. A decree dissolving that Sri Sri Bhattacharya Bhattan Management Committee ad hoc constituted by the defendants declaring it illegal and invalid. If that committee is to be declared invalid, the committee has to be made a party. It is not there. A decree of permanent injunction against the members, office bearers of Sri Bhattacharya Bhattan Management Committee ad hoc constituted by the defendants, debarring them from entering Botodova Than, all that they want. So, by the first prayer, they want that the Botodova Than Management Committee headed by the plaintiff will continue to discharge its duties and functions till its tenure comes to an end, such and such. But they admit that this has already been dissolved. Kindly see at page 26 their statement. Before that, Lordship will see at the same time, I will not. What is their statement regarding the date on and from which the committee came to the existence? They took up the functions. So that 3 years tenure will start. Their statement is here, paragraph 1 itself, page 23, that the plaintiff number 1 is the president and plaintiff number 2 is the executive president of the executive body of Sri Sri Botodova Than Management Committee. So the Than Management Committee as such ought to have been there with all other members, more particularly when there was no registration. The Management Committee constituted in the triennial general meeting of Sri Sri Botodova Than Management Committee held in 2022. Just, this is the statement. Held in 2022. Sri Sri Botodova Than Management Committee is a registered society being registered under Societies Registration Act. It was registered in 1965-66 and its registration number is such and such. Besides overseeing, managing the Botodova Than established by Sri Sri so-and-so is spiritual affairs. We can skip over that. And last line, the plaintiff though will continue to discharge their duties as functions till their tenure comes to a procedural and in May 2025. So the plaintiff though, these two persons will go on working and will complete the tenure. The committee as such is not there. And then, 2, my lord. The Botodova Than Management Committee has been carrying out the daily affairs of Sri Sri Botodova Than. The committee has been holding the daily Nam Kirtan, so-and-so, speaking about this, my lord. The plaintiff has been carrying out the affairs as per the rules of Sri Sri Botodova Than Management Committee. The biennial general meeting of Sri Sri Botodova Management Committee was held at 11 a.m. on 9/6/2024 at I. Kharkhoti Sanskritic Manch. With issue of prior notice, more than 200 members of the general body took part in that meeting. The meeting was presided over by Prabhat Chandra Kalita, the executive president of Sri Sri Botodova Than Management Committee, that is the plaintiff number 2. As per the agenda of the meeting, the reading out of the proceedings, then this is the Lordship will just skip over that part. Then kindly come to page 26, paragraph 3. That there were about 30-35 persons in the meeting when the president of the meeting, that is plaintiff number 2, dissolved the meeting of the second time and came out of the venue of the meeting, and majority of the members were left the venue of the meeting. Subsequently, a section of the members came out of the venue and obtained the signature of the plaintiff number 2 on certain papers by applying force. In that papers, it was illegally written that the body headed by the plaintiffs was dissolved. A new committee, namely Sri Sri Botodova Than Management Committee ad hoc, was constituted in place of the earlier committee, and thus it was shown that the committee headed by the plaintiffs was dissolved. In fact, the executive committee headed by the plaintiff was not dissolved in the meeting that is so-and-so, and there is no provision in the Botodova Than Management Committee rules for dissolution of the committee in such a way. It has been provided in the rules that subsequent to expiry of the incumbent committee, new committee can be constituted in the triennial general meeting. There is no rule of dissolution of the executive committee and formation of new committee in biennial general meeting as per rule go. The tenure of the executive committee is 3 years. Accordingly, as per the provision of rule go, the incumbent committee headed by the plaintiff is entitled to discharge its powers and functions till May 2025. So till May, then, but when they started, nothing. Now, kindly come to 5 paragraph. The defendants have constituted a committee, namely Sri So-and-so Batardaba Management Committee ad hoc. This has not been made a party. With some other members by dissolving the valid and incumbent committee headed by the plaintiffs and gross violation of the rules. And on 12/6/2024, they convened a meeting of the so-called Sri Batardaba Management Committee ad hoc in Batardaba Tourist Laws and asked the plaintiff in charge, Secretary Sri Trikendrajit Dev Goswami, through a letter to hand over all the papers, documents and records of Batardaba to the ad hoc committee within 48 hours. So they came and filed the suit. Now, when we asked for that you hand over the search, they came and filed the suit and kept on holding to it, and they are, with the help of the court's order, they are sticking to it. This ad hoc committee has not been able to function, and they are taking hold of everything. Now, the consideration of the court, of the trial court, in issuing the injunction order was completely different, as if the court wants that this amounts to assailing the election itself, which was held in the triennial general meeting 2 years back. So invalidating this committee means you are setting aside the election itself. And since they have a right to come to the court, balance of convenience is in their favor. In my rational submission, this is not at all sufficient for issuing an injunction. 2 persons filing a suit claim that will manage till 2025 or any date. Will it be permitted on the face of the fact that in a biennial general meeting, this committee was dissolved? They have tried to make out a case for themselves, saying so many things, but the plaintiff number 2, he was the signatory, he himself presided, he himself signed the proceedings. That it was done illegally. The trial court also wanted to know whether any police case was filed thereafter. Nothing. Therefore, question is, the court has to be very pragmatic in such issues. It's a public institution, having so many devotees all over the nation, I would say.
Whether those matters are relating to there's a formation of new committee, no trust motion, all these documents are placed before the trial court.
Trial court, all these documents should have been looked into. No discussion, nothing.
No, whether it was placed before the trial court or not.
In the WS, what I find, those were placed in the WS or the objection petition. It was taken. This was the why such a decision has to be taken. That has been explained, that there was a lot many financial irregularities were found. Therefore, people ultimately wanted that there should be an inquiry done. Otherwise, it will be difficult. It will cause damage to the fund. Therefore, this committee should be dissolved. Ad hoc committee, within 6 months, you complete everything and hold the annual general meeting where a regular committee will be formed, constituted. That was the mandate. That is our WS. Kindly see our WS. (44), Lordship will kindly come to. Page 44 it starts. At page regarding this part, factual, at page 46, my lord, paragraph 16, that it is, Lordship got it?
Got it.
Yes, that it is factually incorrect to state that in the biennial general meeting of Sri Batardaba Parisalana Samiti held on 9/6/2024, the presiding officer of the said meeting, Sri Prabhat Chandra Kolita, left the meeting place due to alleged disturbance caused by few members in the midst of the meeting, and again he came to the place of meeting and resumed the meeting under threat of few members as alleged in the para 2. It is also equally denied that again in the adjourned meeting few members caused disturbance, allegedly caused disturbance for which the meeting closed and the presiding officer left the meeting place. Here is alleged in the same para. All the affirmations made in para 2 are all imaginary in nature and have no bearing with the truth, hence denied. That the affirmations made in 3 are again factually incorrect, hence denied. There is no truth that the only 35 were present when the presiding officer left the meeting place second time, and some members forcefully obtained signatures of the plaintiff number 2. That no force was adopted by any member of the committee to the plaintiff number 2 to sign on a paper. Contrary to the affirmations made in the para 3, actually in the said meeting, Sri Bhatodaba Than Porichalona Committee was dissolved due to mismanagement and corruption committed by the said committee. And in the said meeting, a new ad hoc committee was constituted with defendant number 1 and 2 as president and secretary respectively. The above decision was taken in the said biennial general meeting under the presidentship of plaintiff number 2. The plaintiff number 2 is an educated business person and having various experiences in the field of business and political activity. So there cannot be any question of putting signature on a paper under the so-called threat of members. No police case was filed against such alleged action of few members. The Bhatodaba police station is situated just close proximity with the Bhatodaba Than, but he does not lodge any FIR against the so-called perpetrators for obtaining signature on a paper under due rest. So these all are make belief statement of the plaintiff. The rest of the statements are denied. So this is, we have pleaded our case. But these things were not gone into. The trial court totally misdirected itself. In Bharaspool submission, trial court acted wholly without jurisdiction, misdirected itself, and went to hold that because it was an elected committee way back in 2024, and no action can be taken to dissolve it in a subsequent annual general meeting, biannual general meeting. So this is how it is illegal, and therefore they have a right to sue, and balance of convenience in their favor without discussing the other issues. They have gone and saying that this will continue till the suit processed. Injunction will continue till the suit process. Indirectly, it has revived the committee which was already dissolved. The committee has to be full-fledged committee. Here only 2. They have admitted this door will continue. Therefore, my responsible submission and this restriction to prevent the committee, ad hoc committee as such, is also illegal because ad hoc committee as such is not a party. They have not made the management committee, ad hoc committee which is formed newly, that has not been made a defendant here. Only 2 persons, president and secretary. They are now restrained. The committee as such is, on the other hand, directed not to function. Decree can be passed against the committee that committee has no authority. That cannot be done because this is not a party. But the injunction has been issued. These illegalities are there. Whether it is a question, whether again in such a case, without leave of the court, whether such a suit can be maintained against an institution which is almost a kind of trust is there, interest of people. So many people are involved there. Whether 2 persons can file a suit and install everything. This is answer issue there. Those are not gone into, not discussed. And how the appellate court has considered it? Kindly see that.
No, appellate court has discussed the decision of Supreme Court in a Wender versus Antox.
That is, those are referred to, so many things are said, but are those relevant really or genuine? That is to be seen. Kindly come to page 104.
No, you come to page number 136,
One,
the last paragraph,
one
the
thirty.
penultimate paragraph.
Yes. In view of the discussions, in
Yes,
last
yes.
parameter.
Yes.
In view of the discussions above, it is clear that the order passed by the Learned Civil Judge Junior Division 1 Nagaon is neither perverse nor illegal, and hence the same need no interference. This is the conclusion arrived at. The conclusion must be preceded by reasons. On what ground, how it is so. Therefore, I wanted to point out to the relevant portion. Kindly see, my lord. I'll just point out few things. Kindly come to page 128. Few things are important to be taken note of so that the tenor of the judgment can be understood. Page 128, my lord, Lordship got it. Discussion, that decisions and reasons thereof. Now, turning to the facts in hand, I have gone through the impugned order dated 23/9/24. While passing the said order, the Learned Civil Junior Division, Nagaon, had considered the three basic ingredients necessary for consideration of petition for temporary injunction, that is prima facie case, balance of convenience and irreparable loss and injury, by taking into consideration facts and records and considered the nature of dispute as well as the circumstances involved, and held that the principle of balance of convenience and irreparable loss and injury were in favor of the petitioners, plaintiffs, and hence allowed the pair of temporary injunction of the petitioner, plaintiff, respondents, and restrain the applicant's opposite parties till disposal of the TS number so and so. Pausing for a moment. I have already placed the trial court's order, Lordship has seen it. Save and accept saying that this amounts to challenging the election, therefore there is a balance of convenience. The trial court has not uttered any single word about other required principles to be discussed. Now, whether again there's a prima facie case, how that satisfaction has been drawn, there is also no discussion there.
No, how the trial, no, appellate court has dealt with that issue.
Now, the appellate court has already recorded this. This is a finding. This is a finding recorded. I will take it to the other part also. Can you see at the very beginning, the court has taken note of that what it says, I have gone through the imperial so and so while passing the order dated so and so, the learned judge had considered all the three basic ingredients. Was it so? Factually not. Factually not. Necessary for consideration of the petition of temporary injunction, that is prima facie case, balance of convenience, irreparable loss and injury, by taking into consideration of facts and records. We could not find it. Lordship has read it. There was nothing. But court has concluded it, come to a conclusion, this was there, which is factually not. Therefore, this finding itself is perverse. And kindly see again at 129. So, fourth line, my lord, page 129, top fourth line. So, on this count, there is no perversity so as to consideration of three principles are concerned. Therefore, it concluded, finally, virtually without going through or discussing the reasons and all, the appellate court just concluded showing, so on this count, there is no perversity so far as consideration of three principles are concerned. The concluding sentence as if it has finished everything. Now, my lord, kindly see, then we'll kindly take your lordship to page 131. Second para. It is found that the plaintiff petitioners had sought a relief for declaration that the ad hoc committee constituted on 9/6/24 is illegal, thereby asserting that they are the legitimate body for looking into the administration and management of the affairs of the revered Khan. At the same time, the defendants opposite parties have also claimed that they are the legitimately constituted ad hoc committee for a limited period of 6 months only after the petitioners committee was dissolved at the biennial general meeting. So and so. It is stated that the defendants opposite parties have been entrusted to inquire into the anomalies of the earlier committee, as there are several allegations of corruption and mismanagement of funds against the petitioners committee. Then, my lord, facts have been discussed, much has been argued, and both sides, lordship may skip, kindly come to the later part, bottom, 132 page. Be that as it may, about 5-6 lines from the bottom, be that as it may, the factum remains that the point of consideration here is limited to the order of injunction only. All the other matters related to the legality of dissolution of the earlier committee and formation of ad hoc committee, its right to sue or registration, etc., are the deliberations and adjudications in the main trial. Admittedly, the petitioners committee has been duly elected and has been running the management of the Than. It is also clear that they maintain books of accounts and operate through bank transactions which are documented. It is also not the case of the appellants that the prayers and religious functions of the Sri Sri Bhattardava Than had ceased or been hampered. The devotees are still able to offer their prayers and all pious rituals have continued unharmed, irrespective of despite the Purichalana Samiti. The continuity in function of the management is rather essential at this stage, as the interest of the Than is paramount, and preserving its sanctity is the undisputed motive of either party. If the plaintiff failed to come out trumps in the case, the defendant's appellants will stand validated. Thus, both prima facie case and the balance of convenience under the circumstances are in favor of the petitioner respondents. The cryptic finding in my responsible submission, incorrect finding.
But there is a finding and discussion also.
Well, this finding, well, in my responsible submission, no doubt is a finding. On that point, this may at all first be said that regarding prima facie case. Prima facie case means something else. Prima facie case means whether the suit itself has a bona fide claim, whether there is a bona fide case to be gone into, whether parties have a right to sue. All these things are there. Those are not discussed. Though argued, though placed, nothing. What will be the effect of these two persons bringing a suit? Now, the court says that what it says, management, that the continuity in functioning of the management is rather essential at this stage. For that proper maintenance only these things has been taken. Decision was taken by the annual general meeting that there was no proper management. There was mismanagement. Therefore, it requires an urgent corrective measure. Therefore, it was taken. The court didn't look into that side. As if the resolution which was taken by the general body is the body which keeps a control over the management. Then they have been made businessless. If this is the view of the court, that since this committee was there, they are doing. So, prima facie case, balance of convenience, irreparable loss, everything is there in their favor. Two persons, what injury they will suffer? The rest are going on. If injury is suffered, that injury will self-suffer by the Than, that is the deity, the Than itself. Than is not a party. These two individuals, they will not collect the money. If they are restrained, they cannot collect the pranamis, collections, everyday collections, and there lies the whole thing. They will suffer irreparable loss. That is not their earning. That should go to the Than, main kofar. That kofar will suffer, and our duty is to protect it. Our duty is to protect it. That amount, has not been considered. Interest of the Than is paramount. That is so balance has to be made now here. How to make it, and more particularly when a committee is already dissolved, as I am saying time and again, my lord. When a committee is already dissolved by the general body, until and unless a finding is arrived at after looking into all the papers, that the decision of the annual general meeting, biennial general meeting is not sustainable in law, until that finding is arrived at, this committee cannot be revived, cannot be allowed. Therefore, I opened my mouth saying that by an interim order, the whole suit has been allowed. It amounts to allowing the suit itself. You have a right, you continue till the disposal of the suit. Go ahead. And what remains there in the suit? My responsible submission is, this is not the way how to balance the things. Balance of convenience, injuries, irreparable loss which cannot be compensated in terms of money. But damage, what damage these two individuals will suffer? The greater damage will be suffered by the Than itself, the institution. That aspect was totally overlooked. So, that is why I say, my lord, this finding that thus both prima facie case and the balance of convenience under the circumstances are in favor of the petitioner's plaintiff is a cryptic finding, cannot sustain judicial scrutiny. Then kindly come to next also. I will just point out the last para. The learned last para 33, 133.
Got it.
The learned trial court has also considered the principle of irreparable loss and injury. I don't find any discussion by the trial court on irreparable loss and injury. I have read out to your lordship, so lordship has read it. But court has said, whether court has gone through the records or not, my lord, difficult to comprehend on my part. I have considered the same, and from the pleadings of both the sides, there is no such doubt that the plaintiff respondents were a functional committee looking after the work of the Than till the meeting of 9/6/2024. True, they were there. That is why the resolution had to be adopted. And that all religious or other activities of the Than were continually properly without any hiccups. Continuing properly without any hiccups. How can the court record this? Where from? What are the materials? No evidence, nothing. That the committee was functioning properly, then everything else there. What is the meaning of the suit keeping pending? It has gone to the trial. Without trial, finding is recorded in injunction petition itself. Can it be a legal consideration, legal finding? I am afraid, my lord. No. Than were continuing properly without any hiccups. The allegations raised by the appellant's opposite parties in regard to the charges of the corruption can be determined only after due inquiry by an appropriate authority. That is why the committee was created. Further, the question of legitimacy of the ad hoc committee constituted for the purpose of purpose of 9/6/24 can be decided in trial. True. If this is so, how can you say that you have no right to continue? You cannot function now. If my legality is to be considered in the suit itself, can the court say, no, you cannot work now? You are prima facie illegal. What is that finding? Could be adjudicated only after a full, thus it is observed that the contentions and disputes raised could be adjudicated only after a full-fledged trial. And till then, the best interest of the case lies in continuation of the duly elected committee, who has been until then running the administration of return to prevent chaos and provide continuity thereon. Some, my lord, in my assumption, extraneous facts played the mind of the court. What is chaos?
No.
What is chaos? My lord, it is a kind of
Unwarranted submission.
My lord, no. Kindly consider. Chaos, these are findings. Chaos is a term which indicates many things. Court could have avoided that. And to prevent chaos and provide continuity therein. Continuity is already there. It will be continuing. Thun cannot be stopped. But whether management is properly done or not, this is the issue. There was no chaos as such. There was no chaos as such. Therefore, now, my lord, principles have been discussed. Next para, the preliminary or temporary injunction, even in the nature of status quo, is a provisional remedy that is invoked to preserve the subject matter in its existing condition. Its purpose is to prevent dissolution of the parties' rights. The main reason for use of a preliminary injunction is the need of immediate relief. Preliminary or temporary injunctions, even in the nature of status quo, are not conclusive as to the rights of the parties, and they do not determine the merits of the case or decide issues in controversy. They seek a prevent threaten wrong, further injury and irreparable harm or injustice until such time as the rights of the parties can be ultimately settled. Preliminary injunctions relief ensures the ability of the court to render a meaningful decision and preserve and serves to prevent a change of circumstances that would hamper or block the granting of proper relief following a trial on the merit of the case. Pausing for a moment, my lord, if this is that to prevent a change of circumstances, this committee has already been created. This is dissolved. That situation remains. That was the situation prevailing on the date of filing of the suit. This committee was not existing. It was already dissolved, and this new committee was formed. Then who should be allowed to function? Until and unless a legal finding is arrived at, looking into all aspects, that no, the subsequent committee which was formed, ad hoc committee, it was basically ad hoc committee because committee authorized them to go into the details, come with the reports, place it and hold an annual general meeting where a new committee will be constituted. That was the thing. Therefore, this aspect was not at all considered. Thus, it has to be said that the learned trial court has in proper perspective decided by holding that the petitioner will suffer irreparable loss and injury if the injunction was refused. I will have to repeat the same submission, my lord, when there is no discussion by the trial court regarding irreparable loss and injuries.
Okay.
Therefore, in my rational submission, my lord, the decision referred to by the learned courts below, these are the principle laid down. I have no quarrel, but it has to be applied pragmatically. This pragmatic approach was not there. Here, Lordship will find the first para 135, the first decision itself they have learned court has referred to and has said the quoted the findings, the observations of the court, apex court. Our court, my lord, it is in the Radhabari Tea Company versus Midul Kumar Bhattacharya. Here it says, my lord, in the middle of that paragraph, 1, 2, 3, 4, 5, 6, 7, 8 line from the bottom of that para, my lord, court has said, in an appeal against exercise of discretionary jurisdiction is the legality and validity of the order, and it can be set aside and should be set aside only when there is a patent error on the face of the record or the order is against the established or settled principles of law. I wholly rely on this. Both the order of the trial court as well as the learned appellate court fail to consider this aspect. The orders are patently illegal. Appropriate considerations were not made. Relevant considerations were lost sight of. And then again, my lord, next one, this Ajendra Prasad ji and Narendra Prasad ji, 2005-10 SCC, in this decision, Lordship will say, the quoted portion, it is needless to note that while deciding the issue of injunction, the court have to consider the cumulative factors, that is prima facie case, balance of convenience and irreparable loss. Definite findings have to be given on these aspects on a prima facie basis. And as I submitted, there is no definite finding, no discussion. Only mere finding is not enough. It has to be backed by good reasons. In view of the above principles laid down, the facts and discussed above, it has been the power of the appellate court to set aside, reverse the order of grant temporary injunction, or can even an order of status quo or sought to be adopted is very limited in nature, and the appellant must succeed in showing that the trial court used its power of grant of temporary injunction arbitrarily, capriciously, or perversity. And my case was that this was entire findings of purpose of the trial court. Trial court went into some issues which are not relevant for the case, which court cannot decide also, and nobody is asked to decide. That is my case, my lord. Therefore, and finally, my lord, kindly see, the court has said that the committee will continue to function till the disposal. Should may take another 1 year or 2 years. Do they have that right? They do not have the right. They say that they have a right on their own, say that till May 2025, their term exists. We say that no, their time is already expired. That term has already expired because it was not in 2022, it was in 2021, April. They ought to have. And even if we take it, that they started functioning because there was some irregularity in that COVID period. That time it was backed. All committees were backed. Their term at any rate ended in October 2024. That was our case. Their term ended in October 2024. They could not have. Kuntu? Ketya?
17/3/23 and the date of filing.
So, regarding the query lordship made when the registration failed, registration expired, it was on 17/3/2023. At page 1088, this is there, my lord. The judgment itself, it has been recorded. 17/3/2023 at page 108. Sun Processor is not a registered society under society and it ceased to operate for not having its renewal since 17/3/2023. At page 108, my lord, it is there. Therefore, the appellate court also lost sight of this, that the committee cannot be allowed to continue till disposal of this. And that controversy which arose regarding that date of coming into existence, as I said, they have withheld this material fact from the court. In the plaint itself, although they say that they were elected in 2022, but they have not specified the dates. Material statement was not there. Therefore, in my respectful submission, Lordship may call for the records, look into it, and meanwhile, the operation of this order should be put at naught. That is my respectful submission. And if your Lordship wants to.
No, is it
Here-
necessary to call for the record? Perhaps you have placed all the documents on record.
Yes, yes. Those documents which were there, those were brought on. I don't have all this. What was there? This was in place before your Lordship in the Constitution, some papers, those were there. I am not taking your Lordship now to this. Rest, what is there in the original record, I can't say. But whether those were, there is no discussion in either of the courts that those were the materials placed or that this is the condition of the materials. Nothing. Nothing. Therefore, I cannot make any comment on that. But I can only say on the basis of the findings recorded by both the courts. My argument confines to this. Legally,
Okay,
we
we'll
will look
see.
into that.
Let
is-
us hear him.
Yes.
May I please, Your Lordship?
Yes.
So my first submission would be that the written statement and the claim that has been filed, it is without the documents.
Pardon?
The claim that they have filed and the written statement is without the documents. They have not filed the documents that have been filed with the written statement as well as the claim. So the records would be necessary.
So written statement is a part of the record here.
Here, but without the documents. Only the written statement is there. Along with the written statement, whatever documents was filed, that is not a part of this.
What are the documents?
That Lordship, I do not have the exact information. And along with the plaint also, there were 4 documents. That documents are also not part of this CRP.
Is it with you?
That in my objection, Lordship, I can bring it to in my, when I file the objection, I can bring it.
You want to file
Yes,
objection
Lordship,
here?
I want to file an objection to this thing, and that I'll bring it to in my objection, because all the documents that are there, that is one is objection. I'd like to file an objection. Second, Lordship, regarding the
No, if you want to file the objection, then was it necessary to hear Mr. Monto for a period of one hour?
Lordship, he is pressing for interim prayer. I am objecting to the interim prayer. On prima facie, on the interim prayer, I can satisfy Lordship why the interim prayer may not be. Records may be called for, notices may be issued. Notice I'll receive as I am on KVL. And Lordship show as to the 2 courts, the learned court below the first court and the appellate court, how they have discussed each matter, each cardinal principle. Balance of prima facie case, balance of convenience, and irreparable losses. It's on record. That part is already on there. So regarding other parts, whether I'll show demonstrate Lordship if that be so. I can demonstrate it right away, but I would like to place file the objection. That is my submission. Up to the court, Lordship allows me or not.
No, we'll not object you, but
But I am objecting to the interim operator.
Do you have any submission against the interim prayer
Yes, Lordship.
being made by him?
Yes, Lordship. Interim prayer here, Lordship, my submission against the interim prayer is that both the orders that have been passed, first by the first court and the first trial court and the appellate court, it does not suffer from any illegality or irregularity. Why, Lordship?
All right. You first show me from the trial court's order where the prima facie case and irreparable loss has been discussed.
Lordship. Page 95.
Yes.
First, it starts with heard the learned counsels on both sides. The earlier pages were all regarding whatever the both the counsels have said. and peruse the records along with the document and judgment cited by the petitioners. I have also carefully gone through the entire records of the main case title suit 172/24. All the records were gone through. The learned advocate for the plaintiff's petitioners has asserted that this is a paid case for granting of injunction, more so when the main suit is pending trial and there are grounds to show that the plaintiff has prima facie case to go on trial. He further argues that the balance of convenience is in favor of the petitioners and there is a prima facie case for granting of injunction. Further, he also submits that as the main suit is pending trial, if the injunction is not granted, then great loss would be caused to the petitioners as it would give rise to multiplicity of proceedings. Granting of injunction is an equitable relief, and such a power can be exercised when judicial intervention is absolutely necessary to protect the rights and interests of the applicant. Court must be satisfied that refusal to grant injunction would result in irreparable injury to the party seeking relief, and he needs to be protected from the consequences of the apprehended injury. The expression irreparable injury, however, does not mean that there should be no possibility of repairing the injury. It means that the injury must be a material one, that is, that which cannot be adequately compensated by damages. The applicant must satisfy the court by showing that there is no other remedy open to him in which he can protect himself from the consequences of the apprehended injury. In the instant case, it is the contention of the opposite party that in a general meeting of the Withdrawal Than Procedural Committee held on 9/6/24 under the presidency of petitioner number 2, Prabhat Chandra Kolta, the members present dissolved the Than Procedural Committee by granting no confidence motion due to corruption and financial irregularities and constituted an ad hoc committee with opposite party number 1 as president for a period of 6 months only to inquire about the corruption charges and financial irregularities by the office bearer of the committee. However, it is settled principle that once election process has commenced, it is not permissible to stop midway. In the instant case that the Sri Bhattadeva Than Committee headed by the petitioner were duly elected in the triennial general meeting held in the month of May 2022 for a term of 3 years as per the constitution of Sri Bhattadeva Than, and that the tenure of the petitioners committee would come to end on 15 May 25. The resolution of the duly elected committee of the petitioner would amount to indirectly setting aside the earlier election, and such power is not conferred by the constitution of the Bhattadeva Than so long as the election is not declared invalid in a manner known to law. The resolution of the duly elected body of the petitioner should not have happened. Pausing here, Lordship. Here, there is a constitution. The constitution provides for the election of the.
That's all right, but you answer my question.
Lordship, further the contention of the, then I read the, further the contention of the opposite party that the president of the Than Procedural Committee was not authorized by the general members to file the suit or defend the suit. It was further contention of the opposite party that the society has been governed by the Society Registration Act, and that the bylaw of the Than has not mentioned as to who can sue, and that in absence of any stipulation thereof in the bylaw, Section 6 of the Registration Act shall apply. It is stated that the petitioners have filed the instance suit beyond their authority, and as such, their act is ultra vires. It is further stated that the petitioner has no locus standi to file the instance suit as Society's Registration Amendment Act 2019 in Section 30 has been clearly stated that the society shall be ceased to be a registered society with effect from the actual date of expiration of its original registration. It is also stated that all the devotees of the Bhattadeva Than has interest over the Sri Bhattadeva Than Procedural Committee, but the petitioners have not notified the followers to approach the court about the dispute involved in the Than's management. It is further stated that the suit has not been filed in the representative character nor by an authorized person. Now, by virtue of Society's Registration Act, Assam Amendment 2019, new sections 3B, 3C, 3D have been inserted in the Society's Registration Act. The said provisions are quoted below. Validity of registration. Subject to the compliance of the provisions of Section 4.
Not necessary to.
The validity of the, regarding their part, their submission that the validity of a registration, with the insertion of this provision, the validity remains.
I am asking you about the prima facie case.
The prima facie case is
And this
irreparable loss. Prima facie case is that when the Society Registration Act contemplates that when there is nothing in the constitution as to who can sue and who cannot sue, it is this which will come to our aid. And the prima facie case has been established to that. Now, those will be a matter of trial regarding whether they were the actual members or they had the right to
No,
sue. Because
you tell me, except the submission recorded by the learned trial court, is there any reference to prima facie case in the impugned order?
Lordship, 100.
So you have not gone through the record properly.
No, Lordship, it's there.
Why? Let us do one thing. We will hear you tomorrow. You seems to be not
No,
prepared.
Lordship, it's there 101 if it is. And Lordship, moreover, Lordship, they have to show, first of all, they have to show by the constitution of the fund that whether there is any provision for any ad hoc committee. They, first of all, they have to show whether there is any provision for ad hoc committee. What they are saying is that there is some financial irregularity. Understood, if there is a financial irregularity, there is some misdeeds, some things are there. There it is provided in the constitution what is to be done. Lordship, for a moment, Lordship comes to the constitution, which is annexed. Just for a moment, Lordship. Page 27. This is the translated version. This is the suit which has been translated.
Page number
27. Page 20, the translated version. Or Lordship, I can take you the constitution also. Lordship would like to take, if Lordship allows me to take to the constitution, I can go directly to the constitution. As to look at the pleaded case is on 27. The constitution that they have annexed, which they have translated, page 1. That is 164. 164.
Yes.
Special meeting. Special meeting. By providing sufficient time, 200 members from among the general life or trio members or from any of the mentioned categories may submit a written demand to the president or the general secretary for convening a special general meeting. To demand a special executive meeting, 20 members must sign and submit a written request to the general secretary at least 10 days in advance. Now, Lordship, here any requests, these are the, what has happened? If they had to show that this committee has done these kind of wrongdoings, they had to show from the records that yes, we had conveyed 200 members that signed. Now the question is that it is a 30-35 members as per our contention, it was 30-35 members who have forcefully made us sign the petition number 2. The petitioner number 2 on oath in the title suit have clearly stated that he has been forced to sign the so-called formation of the ad hoc committee. That apart, Lordship, here what they have said, they said that as per their contention only, they are saying this committee was supposedly to look into the financial irregularities. Now, what the learned court below, both the courts have said, that this fund has been functioning. The committee is looking into, the procedural committee is looking into it. This procedural committee was legally elected, which they are also not denying it. They are saying they have formed an ad hoc committee. Now that ad hoc committee, they are saying that not once here, nor neither in the trial court, nowhere they have said they can form an ad hoc committee by virtue of this section of the constitution. Now, nowhere they have said this thing. Now, when there is no source of power to form an ad hoc committee, in my respectful submission, they could not have.
No, that will be decided at the end of trial.
At the end of
title
trial. Now what has happened? Now what is before the court? Which are the two committees that are there? One is the elected committee, which is not denied by them, and one is a committee which is as per the defendants is a 9-6 on a 9-6. It was ad hoc was formed. Now that ad hoc committee was formed, they ought to have shown, they could not, they have not shown as of now. This ad hoc committee was formed as per the procedure of UMO.
So that's all right, but you show me where the trial court has discussed about the prima facie case.
Prima facie case, balance of convenience. Verify. Lordship, I am showing the appellate court.
Pardon?
Appellate
No,
court.
I'm asking you about the trial court.
The first instance.
Yes, yes.
First, appellate court has discussed about the prima facie and the balance of convenience, everything. The trial court has discussed about the balance of convenience in page 101. Balance of he has talked about the prima facie case based on the fact.
So you are admitting that the trial court has not discussed the.
No,
principle
they
of
have,
prima facie.
trial court has discussed.
Where?
Tomorrow, Lordship.
Tomorrow.
That is tomorrow.
Okay, okay.
Tomorrow.
Heard Mr. K.K. Monto, learned senior counsel, assisted by Ms.
And Begum.
M.
And Begum.
N. Begum, learned counsel for the petitioner, and Mr.
RJ Das.
R.Z. Das, learned counsel for the respondent. List the matter tomorrow for further hearing. So, one caveat is there, caveat or the heart, caveat distance research.
29.
Apply.
May I please allow? Worship, this second appeal is directed against two concurrent findings, Your Worship. Now, the appellate judgment, Your Lordship will find at page 59, Your Lordship. Now, the main grievance, substantial questions of law we have framed, and it is in page 3, Your Lordship. But before that, I just wanted to place on record the fact that the learned trial court, while appellate court, while deciding upon the appeal, failed to take into considerations many things with regard to the issues framed as issue number 1 by the learned trial court. The issues which were framed by the learned trial court is at page 21. Your Lordship will find it is in the judgment passed by the appellate court, trial court, page 21 narrates the issues. Total number of 7 issues were framed. If Your Lordship got it at page 21. Now, issue number 1 is important out here, Your Lordship. The suit is maintainable in law and in facts, including point of non-joinder of parties and limitation. Now, in this issue, I'd like to address Your Lordship is that in the plaint, they have challenged the mutation order of 1999, Your Lordship. Now, the suit was filed in 2009. And the trial court as well as the learned appellate court did not dwell into the issue with regard to the limitation, with regard to this. Even the appellate court makes a passing reference while discussing issue number 1 in its impugned judgment. I will take Your Lordship to that part where Your Lordship will find at page 72. Because first of all, mutation is covered under section 154 of the Assam Land Revenue Regulations. These are the subject matter which is barred by the 154 from the civil code. And that apart, the issue of limitation at the bottom, Your Lordship will find in page 72, if I may read out, Your Lordship. Moreover, the judgment cited by the appellants in the form of defendants in trial court by reflecting the bar of section 154 of the Assam Land Revenue Regulation does not get squarely applicable in the facts of the present case, as well as in the nature of the dispute. In the like manner, the point of limitation as well as non-joinder of necessary parties also appear to be non-applicable in the analogous. There is no discussion as to why these are not applicable, nothing, only a three-line point while deciding upon the issues of the issue number 1 by the appellate court, Your Lordship. Though we had in a memo of appeal taken specific plea, if Your Lordship sees the memo of appeal which was filed, these two pleas were there with regard to the section 154 as well as limitation. Your Lordship may come to page 53. That is the grounds of appeal in the memo of appeal which we filed before the learned appellate court, Your Lordship. Point number 3, for that the civil court has no jurisdiction under section 154 of the Assam Land Revenue Regulation to cancel or grant mutation. Secondly, for that the issue number 1 was also not properly discussed with the finding was perverse. Now, issue number 1, as I have taken Your Lordship, was with regard to non-joinder of necessary parties and the limitation. Limitation of a mutation order passed in 1999 is challenged in 2009, Your Lordship. There is no grounds stated as to why there is any delay in filing the appeal as per Order 7, Rule 6. There is a specific provision under Order 7, Rule 6, where in the plaint a specific mention has to be made. If there is a delay in filing the suit, the grounds that is delayed. That is not there in the. However, the trial court as well as the appellate court did not look into that matter. That apart, if Your Lordship kindly come to, because
Whether the appellate court, first appellate court has this frame, this point for determination.
yes, Your Lordship, issue number 1 was the very first thing with the maintainability as well as limitation, Your Lordship. Page 21, Your Lordship will come. That was the very first. Whether the suit is maintainable or not, in facts, including points of non-joinder and party and limitation. Now, this has covered the entire thing. 154, they are discussing, they are saying it is not a bar. Secondly, with regard to limitation, totally silent, Your Lordship. Another aspect which I'd like to draw Your Lordship's attention is in the plain, the circle officer, deputy commissioner had been made a party. Now, in the WS filed by the circle officer and the revenue authorities, which Your Lordship will find in page 46, a specific plea with section 80 was taken by them. That no issue, no section 80 notice was not issued upon them. But those that particular issue has not been taken into consideration by both the trial court as well as the appellate court while deciding the suit, Your Lordship.
Where is the WS filed by them?
WS at page 46, Your Lordship. Defendant number 4 and 5, Your Lordship will find in the plain defendant number 4 and 5 are the deputy commissioner and the circle officer. The plaint Your Lordship will find at page 30. At the bottom is defendant number 4, deputy commissioner Dibrigar, and page 31 is page 5, circle officer. Now their WS, joint WS at page 46, Your Lordship. Your Lordship will find para 1 of the very first page of the WS. The suit as against the answering such and such is not maintainable in law. In fact, it measures firstly the answering to public officers as defined under section such and such, and as such cannot be instituted against them in respect of any act purported to be done in official without serving any notice under section 80 as stated in the cause of action, and secondly has not been joined as a party as required under this for instituting the suit against a purple officer. But in the instant case, so this was a specific plea taken by the defendant number 4 and 5. But in spite of that, if Your Lordship sees, this factor was not even taken into consideration by the learned trial court as well as the appellate court. Appellate court goes in a very simple manner saying that everything is in order and there is no issue to go into it. Does not discuss in details required under Order 47, Rule 20, Rule 31C, Your Lordship. Not discussion as to what the reasons were while upholding the judgment of the trial court. Because as per Order 41, Rule 31, it is the mandate of the statute that the trial appellate court, while discussing the appellatable judgment, will have to look into the matter and decide the matters in toto with the appellate trial court. Here, the simple says that it is incorrect. How it is correct, there is no discussion as such, Your Lordship. Only 3 lines is given with regard to that in page 72. So the main crux of the matter, whether and title suit assailing a mutation order of 1999 can be challenged in the year 2009, as well as whether the non-joinder of parties, etc., were also not taken. Because another aspect is the parties are governed by the Mitakshara law. Now, when it is governed by the Mitakshara law, all the propositionaries are to be made a party. Here, the other legal heirs were not brought on record. And that is also an aspect which was not taken note of, Your Lordship. And the defendant number 4 and 5, the government officials themselves had stated that Section 80 notice were never served upon them. Section 80 notice impact upon the trial was not discussed both by the trial court as well as the appellate court, Your Lordship. That only with regard to maintainability, because Your Lordship is well aware, Section 80 puts an embargo upon taking into aspect with this, Your Lordship. Now, that apart, Your Lordship will find in the suit which was filed, Your Lordship, the prayer while seeking a cancellation of my right, because I am claiming, because the land was of my mother-in-law and the plaintiffs are my sister-in-laws. Now, my husband died. I am claiming my right. I was the defendant out there, defendant number 1. My name was mutated in place of my deceased husband. Now, the plaintiffs are challenging my right over this plot of land. And at the same time, they have not sought for a partition of the suit, land, because if Your Lordship says that their contention was that they were also the legal heirs, but there was not a prayer made in the plain with regard to partition of the suit land, apart from simple seeking a declaration that I cannot be the sole named in the mutation in the Jamabandi.
So on what basis you are submitting that you are governed by the Mitaksara Hindu law of inheritance?
Yes, Your Lordship. Because we are, Your Lordship will find that this they are Satnami, they are the origins from UP, Your Lordship. The plaintiffs as well as the defendant number 1. And Mitakshara, Your Lordship is well aware that apart from the Odisha, Bengal and the Assam belt, the others are governed by the Mitakshara law, Your Lordship. And because of which.
Do you have any document to show that you are hails from UP?
Because Your Lordship, that UP in the sense, Hindi speaking persons, Your Lordship per se, are.
Maybe merely because one is Hindi.
We cannot be, because
he may not be governed by Mitaksara School of Law.
Because the UP belt people, we only the.
So the name and address you have shown here is all.
No, we are no doubt resident of the state of Assam, Your Lordship.
Yeah.
But the thing remains, we carry our thing from the origin, Your Lordship, because Satnani people, per se, Your Lordship, are people who are not origin of the state of Assam, Your Lordship.
Maybe, but you show any document if you have?
That I can, it is not on record as such, but Your Lordship, even leaving those aspect also, Your Lordship, the other aspects are also there, which Your Lordship.
There, we'll see. First, that is the first substantial question of law you have suggested.
Yes, your lordship.
So you showed the relevant document
Lordship, documents I have to bring on record.
by filing an affidavit.
Yes, I have to file an appropriate application, your lordship.
Okay, we'll grant you time. Heard Mr. A. Biswas, learned counsel for the appellant. List the matter immediately after reopening.
Yes, your lordship. May to be
So
parted before your lordship.
enable Mr. Biswas to bring on record the documents to show that the appellant herein are governed by Mitaksara School of Law.
Yes, sir. Let it be parted, your lordship, before your lordship. The lordship has applied the mandate.
So definitely they will list the matter before this court.
It would be better before your lordship.
Item 30.
Okay.
Obliged. Sir.
Kindly pass off the matter for time being, my lord.
There is no time.
Yes.
So may I please, Your Lordship? So,
Is there any caveat?
yes.
Yes, madam. Here on TV.
The caveat-
would be heard. Caveat distance. Yes.
So, this appeal has arisen from an application filed under Rule 97 of Order 21. This appellants are third party. This is an execution proceeding. The application was filed. So, in the execution proceeding or the original suit, the appellant were not parties, but the decretal property was owned by the appellants and in their possession. So that original order passed under 97, Rule 97 is at page 51. So I have heard the learned counsel appearing for the petitioners of petition number so and so under Order 21, Rule 97 and 101 of the CPC dated so and the petition number so and so dated so and so. The last part is the relevant operative part. This it is line 11 from the bottom, my lord. By way of the second petition number, so and so, the petitioners have sought to inform this court that as they are not bound by the decree.
You are
put in-
writing para number?
There is one single para as such. I'm reading from the 11th line from the bottom of
Page
the
number,
page
page number?
51. This is the order deemed as decree passed by the trial court, execution court. Page 51. This is the operative part, last part. By way of the second petition, number so and so, the petitioners have sought to inform this court that as they are not bound by the decree put into execution herein, so being the landlords of the judgment debtors, they have taken possession of the decretal property from the judgment debtors on so and have kept the same under lock and key. Clearly, the petition number so and so under Order 21, Rule 97 and 101 of the CPC is not maintainable in law, inasmuch as the petitioners have themselves indicated that they have not been in possession of the decretal property, and therefore no question arises for them to invoke the provision of Rule 97 by purportedly taking the possession of the property, which in fact has no bearing on the proceeding for execution of the decree. So both the petitions are hereby rejected. So it is clearly stated that we are in possession through our tenants. The judgment debtors in the execution proceedings were our tenants. So we are in possession through our tenants, and during the execution process, we are handed over the physical possession. So being in possession through tenants is.
But you are a third party.
Yes, my lord. So thereafter, Thereafter, the appellants came before this honorable court under Article 227, but this honorable court remanded the case on the ground that there is a alternative remedy in the form of appeal. So we preferred an appeal, which was registered as miss appeal, which actually is ought to be registered as first appeal, because for proceeding under Rule 97, Order 21 should be deemed as a suit by virtue of the provision of Rule 101 and 103. So the appellate judgment and decree, your lordship will find it at page 100.
Page 100.
100, yes, 100. So this is the starting page. However,
100 page here. The last page in
yes,
this petition is
sorry.
71.
Sorry, my lord, 66, page 66, 66. I'm sorry. So this is the starting page, but the operative paragraph is at page 70, my lord. Paragraph 15.
Paragraph
15, 1-5.
Yes.
The last paragraph of the page. The appellant made an elaborate case against the respondent side, due to which the execution proceeding was also stayed for a long time. The instant appeal was posted for hearing for a number of days, but the appellant side didn't submit a single piece of paper in support of its contention. The appellant side didn't deduce any evidence to prove its title over the suit land or to prove how the decree holder of the title execution case number so and so obtained the decree fraudulently. Under such circumstances, I don't see any merit in case of appellant, and accordingly, the instant appeal is dismissed without cost. So this is the ground whereby our appeal was dismissed without giving us an opportunity to participate to adduce evidence. In the first instance, our application was dismissed at the threshold in limine, saying that it is not maintainable. And when we filed the appeal on the ground that a refusal of the exercise of jurisdiction by the executing court under Rule 97/21, it was dismissed, saying that we didn't adduce evidence. There was no opportunity was given to adduce any evidence to state our case. So your lordship will find the appeal memo at page 53. It starts and 63.
So they were not in possession of the decretal land, decretal property.
Yes, we are in possession. We are in possession. First, we are in possession during the proceeding. We are in possession through our tenants, who are the judgment debtors. But in the suit, they have only they have the right to defend only their tenancy, not the title. So therefore, we are not we are strangers. We are not made parties, and we didn't know about the suit. And through tenant, we are possession in through our tenants. So this is a constructive possession, my lord. This is established principle. So this aspect was not, I mean, so the substantive questions are proposed substantive questions are at page 19, my lords. The first question is yes, so our application was rejected, saying that it was not maintainable. The first question relates to that aspect, whether the appellate court below committed error in law in dismissing the misappeal without deciding the question of maintainability of the application. Preferred. Second question, my lord. the without dealing with the question of legality or otherwise of the refusal by the learned executing court to exercise jurisdiction vested upon it for determining right, title, interest of strangers who are in possession of the decretal property. Third question. Yes, the possession, question possession. Whether the learned appellate court below committed error in law in failing to consider whether the findings of the learned executing court to the effect that the application preferred by the appellant under Order 21, Rule 97-101 of CPC is not maintainable as the appellant themselves stated that the judgment debitors were in possession of the decretal property as the tenants of the appellants is in conformity with law or not. Also, the fifth question is important.
So in all the question, you have repeated the same thing.
Not exactly same thing, but this can be, I mean, made into less number of questions.
Mr. Kosek, have you gone through this suggested substantial question of law?
May I just place the paragraph of the order? My friend has not read the first paragraph of the order. Why the court has said not maintainable, it is reflected in the first paragraph of the order.
Which
Page
order?
51, madam. First order, madam. Page 51. Look, this case has got a checkered litigation history, Miller. Malab, this started from 1998, Malab. Malab, may I just place the background first? Malab, the respond number 1 to 4, they first initially filed a title suit, my lord, 37 of 1998, which was decreed against the present appellant's predecessors and the co-sharers on 21/8/1995. On execution of the decree, a sale deed was executed in favor of the predecessor of the respond number 1 to 4. No appeal has ever been preferred against that decree. That decree has attained finality. So my sale deed, by virtue of that decree, has not been challenged anywhere. Subsequently, my lord, the present attorney holder of the appellant's predecessor instituted one suit, title suit 12 of 1999. That is for recovery of possession by evicting me and for compensation and declaration of right title interest and to declare the earlier decree as null and void. That suit was dismissed, appeal dismissed. That decree has attained finality.
No.
Now,
the second appeal is
it is not yet admitted. There is a delay of long delay.
Yes, but it has not attained finality.
So now, my lord, thereafter, the respond number 1 to 4, they filed a suit against the respond number 5 to 9, the judgment debtors in this execution proceeding, for evicting them from the suit premises. Now that decree was executed, and against that decree, there are numbers of applications filed by this appellant for staying the execution proceeding. Now, Lordship will kindly see now page 51. In fact, there has been direction from this honorable court that this execution should not be stayed. It should proceed. And it is a repeated attempt to stall the process of the execution. Page 51, my lord, paragraph, your lordship. Second paragraph. Upon hearing and upon going through the case record, it is found that earlier a similar petition with similar averment with a prayer to dismiss or in alternative to stay the execution of the proceeding was filed by the petitioners of the instant petition number so-and-so, which led to the registration of miscase BLM number 37 of 2019 and which disposed of on 15/5/2019. And the following which there is also a direction of the Honorable Guwahati High Court by order dated 15/7/2019 in CRP case number so-and-so to proceed with the execution without any further delay. By the instant petition, the same petitioners have prayed for stay of the execution proceeding and to hear and declare the joint right title of the petitioners along with their alleged co-sharers over the decretal property. In this regard, it may be mentioned that both in the miscase number so-and-so and in the instant petition, the petitioners have referred to title appeal number 4 of 2017 pending before the petitioners, pending between the petitioners and the decree holders in respect of the property involved in the present execution proceeding, in the backdrop of which the petitioners are seeking for stay of the present execution. However, in this context, the Honorable Guwahati High Court in aforesaid order dated 15/7/2019 has made it clear that in view of the order dated 10/8/2018 passed in IA number so and so, and in absence of any stay order having passed by the competent authority. Now, my lord, pausing here for a moment, my lord, this 10/8/2018 order, where there was an undertaking by the judgment debtor that on so and so that he will vacate the premises. And then, when he did not vacate the premises, this third party came up with this application. And very interestingly, now I'll complete and I'll show one more document. It deserves to mention that the petitioners are well aware of such development, and despite that they have been repeatedly filing the similar petitions one after another. Further, by way of the second petition, the petitioners have sought to inform the court that they are not bound by the decree to put into execution therein. So being the landlords of the judgment debtor, they have taken possession of the decretal property from the judgment debtors on 21/8/2019 and had kept the same under lock and key. Clearly, the petition number so and so is not maintainable in the law, as much as the petitioners have themselves indicated that they have not been in possession of the decretal property, and therefore no question arises to invoke provisions of 97. Now, well, this 10/8/2018 order in the IA, because there was an undertaking by the judgment debtor that they will vacate the premises before the court. And
The judgment, we are not judgment debtors.
There are judgment debtors. Now, when this undertaking did the period that was after the elapse of that period, now this third party made out a case that we have taken possession, because on the day when they have filed this order 21/97, they were never in possession. They were never in possession of the decretal property. Now, the decree, my lord, the entire facts in recorded in the judgment, my lord, against which this execution has been preferred. Now, I don't know why, my lord, the judgment is not on record, my lord. Only the decree is annexed.
Judgment.
My lord, the judgment against which this execution proceeding is proceeding. My lord.
That is not part
that
of
is
the.
relevant.
That is not part. The decree,
is
my
not
lord, will kindly see page 30.
No.
No,
let
this
him-
is
let him-
history. This is history, not relevant, my lord.
No, you first place on record that judgment.
My lord, we are not.
This clearly
This,
shows
our application is the application filed.
May I just complete it? My lord, Lordship will kindly see page 30.
No, Mr. Kosik,
My lord.
let the judgment place on record. We will hear both the party again.
Yes.
My lord.
And there is a recent decision of the Supreme Court that within a period of 6 months, a decree has to be executed.
And this is a execution of
My lord.
15, my lord.
Registry of this court has also issued one notification to that effect.
Yes, my lord.
Whether that judgment is available with you,
That not.
on the basis of which that notification.
My lord, Justice Borua's judgment.
Pardon?
My lord, Justice
No, the
Borua's
Supreme Court does.
No.
Supreme
Court.
No.
You find out the notification, it is available in the website.
This is an
My
execution
lord.
case of 2015. And your lordship will see, both the court has recorded that because of these applications one after another,
But
the execution was stayed.
The fact is, my lord, these are not our applications. This is the judgment debtors. We are not judgment debtors. We are third parties.
We will see the judgment.
So there is some urgency, my lord. We'll file judgment.
Yes.
Before vacation. So it may be taken up.
Okay. Heard, Mr.
All of course.
Oscar, learned counsel for the appellant, and Mr. Kosik for the respondent. Heard in part, list the matter on COVID.
Let it be immediately after vacation.
21st. On that day, Mr. Loskar, learned counsel for the appellant, shall produce the judgment dated
Judgment and decree dated 6/6/2011.
6/6/2011 before this court by way of an affidavit.
Madam 31.
Grateful.
My lord, in this matter, the petitioner has expired and we are unable to contact the legal heirs of the petitioner, my lord. So to file the appropriate petition, we seek for some time so that we can contact and file an appropriate petition in this
Okay.
matter.
Your good name, please?
My lord, P. Bhagat.
Ms. P. Bhagat, learned counsel for the petitioner submits that the petitioner suffered demise, and despite best efforts, they could not compete with the legal heirs of the petitioner. And press for granting her some time, here is allowed, recital is the matter. Since 2015 matter.
Grateful, my lord.
Item 32.
May I please, your lordship? But
Yes.
in this case, service is complete, lordship.
Service
Service is
complete.
complete and LCR has been received, lordship. But fixed for hearing.
Both the parties are represented by their engaged counsel. It is submitted at the bar that that service completed and the matter is, and the LCR has also been received and the matter may be listed for hearing. Accordingly, it is provided that this is a list the matter for hearing.
Lordship, a date may be fixed.
In usual course.
Most obliged, lordship.
Please, your lordship. Lordship, in this case, lordship, compromise was going on, lordship.
Pardon?
And last, lordship may peruse the last order, lordship.
So since the passing of this order about 1 year
Lordship,
elapsed,
but compromise could not be taken place, lordship.
how long it will go on?
Lordship, lordship, I may be to allowed to take press steps, lordship. So
Press
they have
step.
not- Lordship. Last it was taken
Then,
in 22, lordship.
Then why you have submitted that there was a talk for compromise?
But it was failed, lordship, subsequently, lordship.
Mr. Third Mr.
I.E. Chaudhary, lordship.
I. Chaudhary, learned counsel for the petitioner. Mr. Chaudhary submits that though there was a talk of compromise between the parties, the same failed to yield any result, and as such, he may be permitted to take passive step upon the respondent. There is accordingly allowed. Step be taken by registered post with AD and also by usual process within a week from today. This is the matter after this chapter for weeks.
Okay. Interim is there, lordship, that may be continued.
Interim order passed yes, continue.
If you have-
But the lodging order dated 6/2/2025. Services on the respondents have been accepted to be complete, member. 6/2/25.
Or Mr. P.J.
My lord, the issue is,
assisted by Mr. Mishra.
My lord.
Learned counsel for the petitioner.
May I pray for disposal, my lord? It's a small issue, my lord. The amendment was allowed, my lord.
Order dated 6/2/2025 indicates that service upon respondent number 1 to 11 has been completed. But the said respondents remain unrepresented today. Please the matter after reopening.
A date may kindly be given, a small issue, my lord, only.
28.
Place the matter on 28. In the event of subsequent non-appearance of the respondents, the court will proceed to hear and dispose of this petition. On merit.
The interim order mechanical.
Interim order passed are self-contained.
Published.
May I please, my lord? My lord, as per office note dated 29/3/2025. My lord, respondent number 2 has appeared. AD card of respondent number 1 received back with short signature. An AD card of respondent number 3 and 4 has not been received. No. So I may be allowed to take fresh steps on 1, 3 and 4, my lord.
Third, Mr. A.K. Gupta, learned counsel for the petitioner, and Ms. L. Sharma,
Respondent number 2, my lord.
learned counsel for the respondent number 2. Office note dated 29/3/2025 indicates that AD card of the notice issued to the respondent number 1 has been received back with short signature. An AD card in respect of respondent number 3 to 4 has not been received. Mr. Gupta submits that he will take processive on respondent number 1. Accordingly, it is provided that the be taken by registered post with AD and also by usual process within a week from today, list after 4 weeks.
Obliged.
36.
May I please, your lordship?
Yes.
Notice has been served and the LCR has been received. Matter may be fixed for hearing.
Both the parties are represented by their engaged counsel. That is submitted at the bar. That service completed and LCR has also been received. And the matter is ready for hearing. Accordingly, it is provided that this is the matter for hearing in usual courts.
Obliged.
37.
May it please your lordship, before your lordship takes up the matter, I am praying for little accommodation today. Can it be posted after 24th of April? Because I am not ready today actually. Because entire pleading is complete, only argument part is there.
Pleadings complete.
Yes, 3 applications are there, 1 objection and our 1 striking of application is there.
Yes, madam, any objection? No, lordship. Ms. S.B. Gupta, learned counsel for the applicant. First for listing the matter after vacation?
After 24th of April. Your
After 24th of April. Ms. Soduri, learned counsel for the respondent submits that he has no objection in the event of allowing the pair of the applicant. Pair is accordingly allowed. Let's settle the matter.
Lordship, can it be fixed on 1st of May, lordship? It's a hearing day, it will take some time, lordship.
Okay.
Problem.
38, 39.
May I please, your lordship? Lordship, this IA has been filed by us. It was an application under Order 39 Rule 2A. And this honorable court was pleased by order dated 12/1/24 to transfer the application before the trial court to record evidence. Now, the evidence has been recorded and the records have been transmitted to this honorable court for the hearing upon this application, your lordship. Because violation allegation was there by us, because we were the plaintiffs in the trial court and they were the respondents, defendants. The appeal was, the suit was allowed and their counterclaim was rejected. Now against this, they have filed 2 analogous appeals. One is 58 was against the.
So this IA is only for recording evidence.
IA was for violation during the pendency of this, before this honorable court. There was a violation by the defendants against which we filed an application before this honorable court under Order 39 Rule 2A. Now this honorable court taking cognizance of that particular application by order dated 12/1/24 passed in IA 2546 was pleased to transmit the application to the learned trial court for recording of evidence.
Where is the evidence?
Uh, The IA is 4546, 2546, Your Lordship.
Yes.
And the order, Your Lordship, by which it was transmitted, it is 12/1/24, Your Lordship.
No, that's all right.
Yes.
But where is the evidence?
Lordship is separate file is there.
Separate file is there. It is flagged, I think. I think
Okay,
it says-
then we list the matter for hearing.
Yes, that can be fixed for hearing, Your Lordship, because the evidence is on record, has been
Okay.
recorded.
Heard Mr. Episos, learned counsel for the applicant. So for the respondent. Opposite party. Mr. Episos submits that. As per direction of this court dated, order of this court dated 12/1/2024. The learned trial court has recorded the evidence of the witnesses, and same has already been received by the registry of this court, and this IA is ready for hearing, and as contented to list the matter for hearing. There is accordingly allowed, press shall list the matter for hearing on
15 May. Obliged.
Item 40.
May I please, Your Lordship? My lord, here, this is first appeal against judgment and decree passed in a partition suit, my lord, against preliminary degree. They are 150 days delay, my lord. And they have also filed their count objection. In paragraph 4, my lord, I have, of my petition, I have explained the reason of delay, my lord.
If I may, my lord, in this matter, service has not been completed, my lord. Service has not been completed. My lord,
You are for?
appearing for 1, 1 and 2, my lord.
1 and 2.
1, 1 and 2. 1.1.
तो बाकी सवाल करना ना तो कितने वाली कोई for 1, 1 and 2. Then service may be avoided.
Okay. Heard Mr. AI voting. But you have filed Ukalatnama for all the respondents. Are you sure?
Yes, my lord.
Where he has filed objection for 2, 1, 1 and 2.
Okay. And also heard Mr.
G imtiaz.
D.
G imtiaz.
G.
Imtiaz.
Imtiaz learned counsel for the respondent number 1. Roman 1 and Roman 2.
No, my lord.
1, Roman 1 and numerical 2.
Gotcha. Numerical 2. So list the matter after 2 weeks, awaiting service report upon 1 Roman 2 to 1 Roman 4.
I am on.
My lord, if I may, a date may be fixed, my lord.
Pardon?
A date may be fixed, my lord. After 4 weeks, my lord.
23rd May.
GP of the.
No.
41.
Please, Your Lordship. This is a petition for settlement of the claim on compromise, Lordship. The award was for Lordship 15,51,746. It has been settled at that amount only, and some interest. After that, 50% has already been paid.
15,51,000.
Yes, Lordship, as that in para number 2. 15,51,746 is the awarded amount, out of which 50% was deposited to against stay. So 7,75,873 has already been deposited. And
What about the interest part then?
that is the part of the settlement project.
Pardon?
The award was for this amount. We had appealed against that excess award is on the higher side. So they both agreed that it can be settled at this amount without the interest.
Yes.
My lord, this is fair, duly compromised. Your agreement. Only one thing is that I may be allowed to withdraw the amount along with the 50% amount already to 50%, 7,75,875,000 has been deposited, but we have received only 5 lakh.
Where is the judgment of the trial court or tribunal?
My lord, tribunal.
It's in my appeal of memo. Memo of appeal, Lordship. Manju, anybody else?
50%. If more withdraw, 5 lakh.
In a 5 lakhs Lula.
In appeal, my lord, judgment is page number 9, my lord. Memo of appeal.
What would be the amount of 9% interest from the date of filing the claim petition? That is 18/4/2018.
My lord, page number 25. This is the approach on my lord. Page number 25 of the memo appeal, my lord. This is the amount for future loss of income of due to disability 9,67,000, my lord. And
page number
25, my lord. Sale number 2, my lord. 9,67,680 is the future loss of future effect due to disability, my lord. Already High Court held that in future awarded amount, there is no for interest, my lord. Therefore, I am not entitled interest from this amount, my lord. Therefore, already settled, my lord. Settled already High Court held that in future income, there will be no for interest.
Paragraph number?
Paragraph number, serial number 2, my lord. Page number 25.
25.
25, my lord. Future loss of income due to disability.
9,67,000.
My lord. From this amount, I will not
Entitled
to
interest.
My lord.
Part Mr. Goswami, learned counsel for the applicant and Mr.
R. Borua, my lord. R. Borua.
R. Borua, learned counsel for the respondent opposite party.
Number 1, my lord.
Opposite party number 1.
My.
For 2, 2 is the driver.
Is the owner and driver of the offending vehicle.
This interlocutory application is preferred jointly for compromising the appeal, being MSC appeal number 6 of 2024 pending before this court. Mr. Goswami, learned counsel for the applicant, submits that MSC case number 6 of 2024 was disposed of by the learned member Motor Accident Claim Tribunal.
My lord,
Number
MSC
two.
case number 764, my lord.
Judgment is 16/10/23.
Yeah. 764
my lord.
of 2018. Learned member, MSCT in number 2, Kamrup M. Guwahati. Guwahati. Directing the appellant in MSc appeal number 6 of 2024, and the applicant, one of the applicant herein, to pay a sum of rupees 15,51,776, being the compensation. Being the compensation. With interest at the rate of 9% per annum from the date of filing the claim petition. But Mr. Goswami submits that now both the parties have arrived at a settlement, and now during the pendency of the appeal, both the parties have arrived at a settlement, and one of the applicant herein, that is the appellant in MSc appeal number 6 of 2024, is agreed to pay a sum of rupees 15,51,746 rupees, and 50% of the aforesaid amount has already been deposited before the registry of this court. And therefore, Mr. Goswami has contended to allow this interlocutory application. Mr. Borua, learned counsel for the respondent number 1, submits that the matter has been settled amicably between the parties, and as such, this application may be allowed. Taking note of the submission of learned counsel for both the parties, this court is inclined to allow application and allow this application. The applicant appellant Serum General Insurance Company Limited is directed to pay the remaining amount of rupees 15,51,746 rupees directly in the account of the respondent. Respondent number 1.
The remaining amount of 775,873.
Yes. Remaining amount of rupees 15 lakhs 51,746.
That is the total settlement.
Yes.
After payment of 775, we have to pay.
Remaining amount.
Of.
Remaining amount of this amount.
Yes, yes.
That is 7,75,873 rupees.
Yes, sir.
Directly in the account of the respondent number 1, respondent opposite party number 1, by NEFT. Mr. Borua submits that the amount deposited before the registry of this court may be allowed to withdrawn by the respondent number 1. Here is accordingly allowed.
Along with the, my lord, 50% which was earlier deposited, my lord. Out of 7,70,000.
That amount, yes.
7, my lord.
You will be entitled to withdraw from the registry.
My lord.
The other amount, the party will directly deposit
My
in your
lord.
account.
My lord. My lord.
Then that statutory deposit?
That may be refunded. This may be not.
Mr. Goswami also submits that the appellant applicant herein may be allowed to withdraw the statutory deposit made at the time of filing the appeal, where is accordingly allowed, the statutory amount shall be released in favor of the appellant.
Applicant.
42.
May it please your lordship. In the main CRP, your lordship, we have basically challenged the order in appeal by way of which the interim injunction that was granted by the trial court was modified and the injunction was in fact withdrawn. So that is under challenge in the main CRP, your lordship. This petitioner, your lordship, is residing over a plot of his residential house for many generations. It is having patta number 82, 83, DAG number 335, 336, 337, and all these things, your lordship. He's residing there for about many generations, your lordship. Suddenly in the year 2018, a notice was issued on 18/8/2018. On 18, a notice was issued on 22/2018, whereby it is found that some portion of the house premise of the petitioner was sought to be evicted on the ground that it is a government land. The petitioner were never aware that some portion of their house and there are some government lands or caste lands have gone there into. So, your lordship, at that time, initially they approved this honorable court. And this honorable court, your lordship, heard the matter, and thereafter the court has passed an order, which your lordship will find at Annexure 1, page number.
No, we are not hearing the CRP now. This IA is for what purpose?
For IA, your lordship, in the meantime, during the pendency of this CRP, your lordship, they have been.
No, are you pressing this IA now?
IA, there was they had issued an order for eviction, however, by that has not been executed, your lordship.
No, on the other day, perhaps we asked you not to.
Yes,
execute,
yes. That is why it was not executed.
It was till 1st of April.
Yes.
But perhaps also no.
No, lordship has not passed any order.
It was
order was
just
passed.
verbal,
Yes,
lordship. It
verbal.
was verbal, but no order has passed. See? But it was verbally,
Yes,
this
yes.
honorable court has directed that till April 1st, not eviction should be not. But it is a khas government land, lordship. There, I have received the instruction that is.
I have gone into CRP because for disposal of the IA also, lordship would have to go into the CRP. That was, I started with the CRP.
And what is the impugn order?
Lordship. Impugn order, lordship will get,
87.
Yes.
87.
it starts from page 87. But the relevant is page number 95. Relevant page is page number 95. May I read it? Starts from paragraph number 11.
So the trial, first appellate court has set aside the injunction order.
Yes. Set aside.
Against that order, you are before this court.
Lordship.
But whether CRP will lie? This is against the injunction order.
Injunction order.
Injunction
Then
order, but
appeal will lie.
injunction order, but it was finally decided. It was against miscellaneous appeal, your lordship. The order that was.
No, for any order.
Now, lordship will find that the learned trial court below, the appellate court below, that has considered the matter in an appeal, your lord, miscellaneous appeal.
Acha, okay.
So against appeal, we cannot again come for appeal. Therefore, this revision petition was filed, your lordship.
Yes, Mr. Gogoi, what instruction you have received?
Lordship. The injunction order was lordship clearly stated by the trial court. Still the completion of the ascertain and demarcating the suit class T49 from its A to Z point as indicated in the revenue map. Now, it was already conducted, already demarcated as per direction of the Honorable High Court. They came before this Honorable High Court in the WPC manner, Lordship. That was also dismissed. And this Honorable High Court was directed to revenue circle officer, settlement officer, to demarcate the actual cast dark land of the government cast dark land. We already demarcated, Lordship. Now construction work of the 154 National Highway is all due to illegal occupation of this land, Lordship. And it petitioner here in Lordship clearly it is proved that he is an illegal occupier. An illegal occupier has no authority to justify his illegal occupation to a lawful manner, Lordship. We are the lawful authority. Our khas land has illegally occupied the instant petitioner, Lordship. So, due to this illegal occupation, the construction work of the national 154 National Highway is halt, Lordship. That's why we are trying to evict, Lordship, only because of public purpose. And Honorable High Court also directed that before the eviction process, we should have to demarcate the khas government land. Now it is over, Lordship. And page 82, Lordship, main petition CRP, Lordship, page 82. This is, Lordship, got it, Lordship.
No, as per order in the writ petition.
Lordship.
So the state was directed to carry out the process of demarcation.
Lordship.
Of the boundaries of the plot of land.
Already
And
conducted.
thereafter, you have demarcated the boundary.
Lordship.
Where it is stated that you have completed that exercise?
Lordship. The evidence judgment, it is stated, Lordship. Page number 9. Page 95, para 12.
In the memo of appeal?
Lord.
No, in the CRP.
CRP.
Page number?
95, para 12.
Yes.
Para 12, Lordship.
Yes.
However, during the pendency of the appeal on 16/11/2023 and again on 4/12/2023, the respondent authorities, in particular the Circle Officer, Hailakandi Revenue Circle OP number 3, after giving due notice to the parties, caused a survey of the disputed land covered by DAG number 349 from A to Z point. A test may be also prepared by the revenue authorities, clearly indicating the land covered by DAG number 349. The said report forwarded by number so and so, dated Hailakandi, dated 9 February 2024, issued by the Circle Officer Hailakandi. Revenue Circle is submitted in original by the learned government pleader to this court. It is also indicated in my instruction, Lordship. My instruction, I have tagged it, Lordship. Annexure F. This is the letter. I'm already playing, Lordship. Lordship. Submission of the Gulf Khas Land Demarcating Report of the Moja Narayanpur Part 2. With reference to the subject cited above, I have the honor to enclose here the demarcating report of the Gulf Khas Land covered by DAG number 349 at the Moja Narayanpur Part 2 in connection with WPC number so and so, corresponding to Miss Case A so and so, arising out of Miss J case number so and so, corresponding to TS number so and so, pending in the court, learned civil judge Hailakandi,
regarding demarcating of golf class land under the dock number 349 comprising an area of 15 sort of starting from point A to Z point before conducting eviction drive of the enclosure from the golf class land, which was submitted to the DC Hailakandi by this office issue number so and so dated 7/12/2023, which is self-explanatory. It was submitted to the landed district judge. So demarcating process as per direction of the Honorable High Court we have conducted. Several notices already been issued to the instant petitioner lordship. Now construction work of the National Highway 154 is halted due to the illegal encroach of the by the instant petitioner. That's why it is necessary to conduct the eviction drive so that the holding construction work of the National Highway 154 is smoothly conducted.
So, Mr. Locker, there are two decisions. One is of this court in writ petition and the other is of additional decisions. Then as per direction of this court in a writ petition, they have also carried out demarcation process. Where is your case now?
No, Lordship, they are saying about National Highway because earlier when the case was there was no question of National Highway. It was a case, it was a village road. I don't know. I don't have any instruction whether there is a National Highway project going through my land or not. Earlier it was their case that a public road was there, which subsequently was not it is total some 12 khatas are there. I may be on 2 or 3 khatas. I don't know because only his plot of land that is under the question in title suit. Now, my lord, the case is that I am not onto that they have done the demarcation. There was a clear direction from this Honorable High Court that before carrying out eviction, they have to go for a
Demarcate the process. And the letter
Yes.
he has just now read.
Yes.
It is clearly stated that they have carried out the demarcation process.
Now, it is their communication, it may be your lordship. Now, my case is that your lordship. So after that order, your lordship, they did not carry out any demarcation. By that time, I have filed. By that time, I have filed a title suit, your lordship. Title suit seeking a direction that since I am possessing this for a long period of time. There was Demarbar in whispered that some government left have encroached into my land. I filed a title suit for declaration of the right title interest over the suit land. And I have also filed a specific petition, your lordship, under Order 39, Rule 1 and 2, seeking injunction. They have filed their written statement in the injunction petition also. After hearing both the parties, your lordship, the learned court below has passed an order, which your lordship will find the initial order at page.
No, that has already been set aside by the
No,
appellate court.
that is correct. Whether the learned now, when they filed an appeal against that order, there was no any whisper or saying that they have already done the demarcation. The appeal that was filed, your lordship.
No, during the pendency of the appeal.
No, if during the pendency of the appeal, your lordship, they have done some acts, then the proper procedure is Order 39, Rule 4, your lordship. They have to go to the trial court and say that this is the thing we have.
No, they have submitted it to the court.
Lordship. No, lordship. Maybe they are your lordship.
You furnish a copy to him.
Lordship.
This letter and let him obtain instruction. And there is no stay order now.
Lordship.
Let it be on Tuesday then. Okay. Sure. Or after vacation.
There is no stay.
Pardon?
Stay should not.
No stay. No stay. No stay.
So an eviction, they will carry out the eviction purpose will not.
Whatever be the consequence.
No, lordship. My case is that
the injunction order also clearly reflected that.
Yes, order is there. Order
clearly. Page number 82, lordship.
So you obtain instruction, therefore we will hear you.
No, I'll obtain instruction, your lordship. But in the meantime, if they carry out the eviction, nothing will survive.
Whatever they will do. There shall not be any stay.
No, lordship will kindly see the impugned order, your lordship. It is however, during the pendency of this appeal, means when the appeal was pending, your lordship, in between they have submitted on 16/11 and again on 16/11/2023 and again on 4/12/2023 the respondent authorities, in particular
you first obtain the instruction.
No, I'll obtain the instruction also.
It was as per the direction of this.
Thus, it appears that the direction of the Honorable Guwahati High Court is complied with. Thereafter, the learned court will have said, as the reason behind granting injunction is already fulfilled,
in the manner stated above, the injunction order dated so and so passed by the learned trial court automatically becomes infructuous. Although the learned trial court did not commit any wrong in passing the injunction order impugned herein, in view of the compliance of the directive of the Honorable Guwahati High Court, the impugned order stands asserted. If the injunction order, the learned court has not committed any wrong, your lordship, in passing the impugned order, whether
No, there is direction of this court in writ petition.
No, writ petition is
Go and challenge that order.
correct. Writ petition is there, your lordship. Writ petition order was there that they should carry out a demarcation. Now, if they approve, the remedy is there in order
First
39
you
rule
apply
4, your lordship.
inspection.
Order 39 rule 4 is the remedy, your lordship. I'll just go through order 39 rule 4 for a moment, your lordship.
No.
If an injunction order is there,
Instruction.
and if the lordship, I'll obtain instruction into that, there is nothing. But in the meantime, if they carry out the eviction, nothing will. And it is
There shall not be any stay from this court.
No, there is nowhere in the petition they have said that a work of NH 54 is stalled because of this. Where it is there, your lordship. NH 54 work is not there, your lordship.
Third, Mr. Laskar, learned counsel for the petitioner, and Mr. Gogol, learned junior government advocate for the respondent number. Gogo, you are for respondent number
1 to 4.
Instead of instruction, your lordship will fix it on Tuesday, will finally hear the matter and dispose it of.
Tuesday.
Or Wednesday, your
already,
lordship.
lot of matters have been fixed.
Lordship dismisses it, then it goes okay. But if the CRP is there, your lordship, and lordship has.
Pardon?
If lordship takes up the whole matter and disposes it of your lordship, then it's.
No, that's all right, but before vacation would not be possible. Ten.
Let it be on
Okay,
10th.
10th. কি করলো না এটা? Mr. Gogoi, learned junior government advocate, has produced written instruction received by him from the Deputy Commissioner Hailakandi. A copy of the same be furnished to Mr. Laskar to obtain necessary instruction, and this is the matter on 10th.
43.
Till then, your lordship, I may be protected. Till 10th, I may be protected.
Pardon?
Till 10th, I may be protected.
No. It is in public interest.
No, definitely. your lordship.
There cannot be any stay.
Public interest, but oblige lordship.
My lordship, let's say I for allowing me to withdraw the deposited 50% deposited amount, my lordship. This is the injury case, my lord.
Yes, any objection?
Objection, lordship, but I leave to your lordship if they can furnish a bond, lordship. if
Why?
But there is no any violation, my lord. There is any
Otherwise, the
violation of
appeal is
the
on
policy.
quantum, lordship. Otherwise, the
It
appeal is
is
on quantum.
quantum, my lord. Already everything is.
Heard Mr. Borwa, learned counsel for the applicant. And Mr. Sarma for the respondent of
Respondent insurance company, lordship. Respondent number 1.
1.
This interlocutory application under section 151 of the Code of Civil Procedure is prepared by the applicant for allowing him to withdraw a sum of rupees 8,25,738 rupees being deposited before the receipt of this court by the respondent number 1. Please, Doctor.
Oriental.
By the respondent opposite party number 1, that is the Oriental Insurance Company Limited. By which order it was deposited before the receipt of this court?
My lord, page number 4, my lord, paragraph number 3, my lord.
Page number 4, paragraph number 3.
3, my lord.
Mr. Borwa, learned counsel for the applicant submits that pursuant to an order dated 12/2/2025 passed by this court in IA, which will make it C, number 64 of 2025. The respondent insurance company has deposited 50% of the awarded amount, that is rupees 8 lakhs 25,738 before the registry of this court, and the applicant may be allowed to withdraw the aforesaid amount. Mr. Sharma submits that he has no objection. In the event of allowing this application, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The applicant is allowed to withdraw the sum of rupees 8,25,738 rupees deposited before the registry of this court. In terms of this, I instance closed.
Deeply.
47. 47.
This is, Lordship, fixed for dismissal, because.
Fixed for dismissal.
Yes, Lordship will find the last order, there is indication. If lost.
Lordship, we have filed an intimation, but we have lost every possible contact with the appellant, legal heirs of the appellant.
Last order is 19/3, Lordship.
So there is no sense.
No, your Lordship. We don't have any proper address.
Sir, you not learned counsel for the appellant.
No, I am for the respondent.
Respondent. Your good name, please?
S. Sharma on behalf of D. Chaudhary.
S. Sharma, learned counsel appearing on behalf of
D. Chaudhary.
P. Chaudhary.
D. Chaudhary.
D. Chaudhary, learned counsel for the appellant, and Mr. Yudat for respondent number.
Sole respondent.
Sole respondent. Ms. Sharma submits that Ms. Sharma submits that despite best efforts, they could not make any contract with the legal heirs of the appellant who had already suffered demise. And Mr. Dr. Learned counsel for the respondent submits that in view of the order dated 19/3/2025, the appeal should automatically abated. Taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this appeal by holding that the same instance abated. In view of the order passed in this appeal, Dismissal returned LCR to the learned courts below.
48.
Obliged.
May I please solicit? Lordship. RSC Lordship 48 of the 24 Lordship was listed on 19/3/2025 Lordship. And on 19/3/2025 Lordship, earlier the RSC was listed on 19/7/2024 Lordship. What happened on that day Lordship, in the cause list Lordship, the earlier engaged counsel name was appeared and newly engaged counsel name was not appeared on that particular date Lordship, and therefore the RSC was
We will issue notice. Heard Miss
K. Malakar.
A.
K. Malakar Lordship.
K. Malakar, learned counsel for the applicant. This application under Order 41, Rule 19, read with Section 151 of the Code of Civil Procedure is prepared by the applicant for readmission of RSA number 48 of 2024, which was dismissed for non-prosecution by order dated 19/3/2025. That notice be issued to the respondent. Returnable respondent opposite party returnable in 4 weeks. Step be taken by registered post with AD and also by usual process, which I know it from today, list of the courts.
Lordship, there is a interim order earlier, Lordship, there is a stay order of execution proceeding, Lordship. In the meantime, Lordship,
No, unless and until we restore the RSA to file, we cannot. Rather, we can fix a short date. You can serve the notice by the same month. That we can permit.
yes, Lordship.
List the matter after 2 weeks. Justice service is also permitted.
49.
May it please your lordship. Your lordship, this is a delay condonation application. This is a delay condonation application. Your lordship, a common judgment was passed. In on the against
What is the duration of the delay?
35 days. Your lordship.
35 days.
Actually, your lordship, what has happened was there were two orders which were challenged. The RERA appeal number 3, it had
Okay,
come up
this
on
is notice will go. Heard me, sir?
C. Gogoi, your lordship.
C. Gogoi, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act 1963 is read with section 58 of the Real Estate Regulation and Development Act 2016. Is preferred by the applicant for condonation of delay of 35 days in filing the appeal against the order dated 19/12/2024 passed by the learned tribunal in REAT appeal number 23 of 2024.
Your lordship, may I just make one suggestion? There were two orders. On the last week, your lordship, a coordinate bench of this honorable court had directed that since we had filed one appeal against the common judgment, we have to file two appeals. So the connected appeal has already been heard by Honorable Justice Devashish Bora. The order is annexed. So this is only a connect, since it was directed that since two orders were disposed of, so we have to file separate appeals.
No, does it mean that we have not to condone the delay?
However, that is just my submission, your lordship. One order has already been filed on time. One appeal.
Whether this delay of 35 days in filing the appeal is not required to be condoned? Issue notice to the respondents returnable in 4 weeks. Step be taken by registered post with KD and also by usual process within a week from today. List after 4 weeks.
Obliged.